We are about a minute away, so I'm going to get started in just about 1 minute. Hello to the Zoom universe. Hopefully you can hear me. I will try to look up and talk to you sometimes, but I'm going to focus mostly on our people here in the room. But no offense intended, and I will try to keep an eye on the chat box as well. Where are we at? So I'll give you all a minute to settle and we'll get started. So it looks like our minute is up. Wasn't a minute at all. All right, good morning, everybody. It is 9 o'clock. For those of you who have not been to my classes before, I do my best to finish on time. What ends up happening is I don't finish on time, so I speed talk through the end of the program. So I will finish and it'll be on time, but you'll catch me talking fast at the end and we'll make it through. We'll try to take breaks like we're supposed to. Again, we'll kind of see how the flow of the class is going. But we'll try to intersperse breaks in there so you can grab some more food and grab a bathroom break if you need it. So with that said, give everybody a chance to get settled and we will get started. And again, to the Zoom room, let me just see how this is working. Everybody appears to be able to hear me. And there's a bunch of you there. That's great. So I think I've got this set up. So with that said, we will get started. I am Jonathan Lack. I am a transactional real estate attorney with the law firm of Lack & Lack Chartered. Lack & Lack Chartered is my father and myself in practice together. Now, Dad has just crossed over the 60-year mark of being a Florida bar attorney. He has somewhat retired now. So Lack & Lack is really mostly just me. I've only got 30, yeah, exactly. So I only got about 32 years of experience myself, 35 in the title industry. So I still bring something to the table and I still consult with my father whenever I need him. But with that said, I first want to introduce our sponsor, as the sign says out there. A huge shout out to our sponsor, Waterview Title Services. So everybody give it up for Waterview Title Services. Thank you, everybody. Thank you. Hi, I'm John Lack with Waterview Title Services. Welcome to the show. I hope you have a good time. There's lots of food there, or probably more food than we need. So please feel free to eat up. Feel free to take a doggy bag. I have been doing this class, Attorney Lack has been doing this class for 16 years now, since 2006, and I've been teaching it regularly for a long time. Waterview Title has been a sponsor for most of that time, but rarely have I pitched Waterview Title. But I am in a change of circumstances now, and I am in a growth phase with the company. So you're now going to get a little more of a sales pitch than you might have gotten in the past. So Waterview Title, what makes us stand out? Experience, expertise. As I said in the opening, my father has been an attorney for 60 years. All of that time is spent in the title insurance industry, either with an underwriter or out on his own. He formed his first company in 1979. I joined him in 1987. We formed Waterview Title in 2003. So Waterview Title only has 19 years experience, but the predecessor company had 25 when we shut them down. And so really 43 years operating a title company. So that is our expertise, our experience. You cannot underestimate the value of experience when it comes to real estate transactions. We've seen, I still don't want to say I've seen it all. I still see new things all the time, but I know how to navigate those new things. I know how to deal with them. I can see problems on the horizon and navigate around them or fix them or prevent them from happening ideally. The other thing that we offer is the legal services are available, the legal support. So when there is a problem, because sometimes there's inevitable problems, then we have Lack & Lack as a team to provide legal support to the transaction, whether it's document preparation, escrow agreements, easement agreements. I'm well-versed in probate matters and know how to navigate the probate system, so we can take care of that whenever there's a trust involved. Basically, the entire breadth of real estate experience we've experienced at some point and are able to pass that knowledge and experience on to the transaction. So Waterview Title, there are great title companies in this area. I work with a lot of them refer business to me as an attorney. And again, that's where we stand out. The other title companies do a fine job, and I will not name any names and I will not knock any of them. I work with them and I like them, but Waterview Title can do what they do and more. And I am, as I said, in a growth phase. So over the years, I've not sought your business because I've had enough business and I honestly didn't need to ask for it. But now I am growing. I've added some employees. My plan is to focus my attentions more on the title company. Not that I won't be doing the law office, but I'm going to focus on the title company and growing that. And again, the law office will still provide support to Waterview Title. So the other area where we are outstanding is there are also a number of very good real estate firms in this town, and they can do what I do as well, but they don't have the title agency experience. So real estate firms can write title and they, again, do a very good job, but a title agency is more of a volume, more of a taking care of the whole thing the way you guys are used to. And a law office is more the boom, 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 and getting it right. And both work well together. I do both. So Waterview Title, again, offers you more than the big title agencies because we have the legal support, and more than the law firms because we have the title agency support. So that's my pitch for Waterview Title. I hope you guys will give us a shot, send us some business. I work with many of you, again, those in Zoom, and a lot of you may be new realtors, so maybe I haven't worked with you yet, but realtors are calling me regularly for legal advice. I even end up representing a lot of realtors and or their clients. I am now asking that you put my name on the, when you get a listing, put Waterview Title as the title agent, give us a shot at that end of the game, and you'll see that we do as good a job for that as I do for you as an attorney. So Waterview Title Services, John Lack, and now I turn it back over to Attorney Lack, and I hope you have a good morning. Thank you, John. That was very good. And I worked with you for many years, and I think you're very competent, and I think everybody will look forward to working with you as well. All right, so again, I do thank you all for the time. I'm not a salesman, so it's hard for me to actually ask for business, but that is the nature of sales, and all of you pretty much know that, I assume. So hopefully that's okay. All right, so what we're doing today is the contract class. What I really do like to do is educate. I like the community to improve by knowing what they're doing. The more you guys do right, the less I have to act as an attorney, and I don't want to act as an attorney, as I said, I want to act as a title company. So if I can get you doing this right, then the calls will be closings, not we have a problem. So what we're going to do, the way my class runs, is I literally am just going to go top down. I've got my little notes. This is my cheat sheet. I do wing it. I have a cheat sheet with notes, but it's not scripted. So I will jump off in tangents, and something will pop into my head and I'll just fly off in another direction. Thanks to the cheat sheet, I will always circle back eventually. But I also often forget to change the clicker here. So if I forget, oops, it's not working. So I got to do that. So if I forget that, somebody just kind of look. Now I do scan the room the whole time. So if somebody has any questions, just kind of catch my eye, raise your hand, and then wait. I take questions at the end of each section. So if you look at the contract, there's parties, then there's property, then there's purchase price, and I'm going to do those in sections, and I'll take questions at the end of those. What happens, which I enjoy, is I enjoy the questions. It keeps it different and interesting for me, and it's answering questions that you guys have at any given time. It makes the class different, but sometimes it makes it also run long. So if we find that we're running long because of questions, then I might have to cut them off. And again, Zoomers, I will do my best to look down here. Kathy has told me sometimes I forget to check that. So I'll do my best on the chat box if you have questions. Again, I won't answer them till the end of each section, but I will do so as quickly as I can. Some preliminary items. Unless you are a licensed attorney, the preparation of a contract is considered the practice of law. And unless you're licensed, preparing a contract is the unlicensed practice of law, and it is a third-degree felony. So every time you guys do a contract, you're committing a third-degree felony. So Bad news. Good news is the state of Florida said, wow, we can't have all of our realtors end up either in jail or paying fines for third-degree felonies, and that doesn't look good on their permanent record. So we need a solution. So the Florida Bar and the Florida Association of Realtors got together and they said, you know what? Realtors need to be able to prepare contracts. Well, you're not preparing a contract, you're completing a contract that has already been prepared by attorneys and such. So you're filling in the blanks of a contract. You're not drafting one yourself, you're using the form that's already there. So what I want to teach you today is how to properly fill out that form, because even though the form is there, there are a lot of choices to be made. There are check boxes that need to be checked and they have relevance. There are blanks that need to be filled in. And if they're not properly filled in, while it might not constitute the unlicensed practice of law, it certainly borders on negligence if you do it improperly. And again, you don't want to have any problems because you didn't prepare the contract correctly. So if you have questions, if you feel like you're having to draft legalese, if you're not sure of what it is, call me. Now, if it's not me, I also highly recommend, whether it's me or anyone else, you get to know a transactional real estate attorney, not a divorce attorney, not a criminal attorney, not your brother's cousin's uncle's friend who, did traffic tickets in his youth. You need a real estate attorney who understands real estate law and contracts so that they don't, if you get a corporate attorney who's going to draft great language, but they don't understand how transactions take place. Or if you get a divorce attorney who's always looking for a fight, so they'll draft great language, but they don't understand how transactions take place. Our goal, my goal, attorneys have gotten a bad rap over my career because they don't get an attorney involved. They're going to mess up the deal. They're going to cause trouble. It's going to be a problem. It's only a problem if you get the wrong kind of attorney. I don't cause trouble, I fix them. When there's a problem, I find a solution for it. I don't create a problem. Now, with that said, the other little part of my speech, I am an attorney, I represent a client. Unlike realtors, and full disclosure, I'm also a real estate broker. So I have come to the dark side, your side of the table. No, I said that wrong. I am on this dark side, you guys are the light. So I do understand what it is to be a realtor, and I understand what it is to get the deals closed. And that is our goal to do so. And I completely lost where I was going with that train of thought. So, so I will either bounce back or I won't. Yep, it's gone. So with that said, I'm going to go ahead and get started. As I say, when it pops back into my head, I'm going to pull it back down and speak to you on it. But right now, in the interest of both time and keeping you awake, we're going to go ahead and get started on the contract. So when I first started doing this a long time ago, well, it was the 2004 version of the contract, and it was in 2006 that SCAR invited me to start teaching the class. I had looked through it and I saw, what are all those little asterisks? And it turns out the asterisk indicates a blank to be completed. So I figured I'd put that up there so you'll all know and won't have the question. All the lines are numbered, and if a line number has an asterisk next to it, it means that there's a blank on that line. Pretty irrelevant to you guys because I'm assuming you're doing it on a computer and you're bouncing with the tab from field to field or whatnot, or even a different way of completing the program. But in the old days, when you had a legal pad of the 4-page contract and you went through and wrote them out and poured them off, that might have been useful, though again, a blank line's a blank line. I think it's easier to see than the asterisk, but that's what the asterisk is. Now, ready to dive in. This is the meat of the program. Any questions before we get started? Anybody in Zoom? Okay, here we go. So we're starting with the parties. We're going to start with the seller. The seller is the owner of record, and the seller, you get the name from the deed, right? So how many of you, I've been doing this so long, I sometimes ask questions that are almost silly, but how many are familiar with the Brevard County Property Appraiser's Office? Right, so bcpao.us, and that's probably where you all go to start whatever you're doing when you do real estate. Me too. You go to Brevard County Property Appraiser's Office, and of course, if you're working in another county, if you're working in Broward or any other county in the state of Florida, you go to their appraiser's office. They almost always have, or they always have, what I call a mini chain of title. They show the last deeds of record related to that parcel. And it's usually got to scroll down a little bit and you'll see the sales history, they might call it. And there's usually a place to click on the deed. It'll have a little our booking page and you can click on it. It'll bring you to the property, the clerk of courts. And the clerk of courts are where the official records, the deeds, mortgages, easements, things like that are stored in the public record. So you look at the property appraiser's site, it'll have names on it. It'll have a legal description. It's great for knowledge and value, but go to the last deed of record. The last deed of record is how the owner owns the property. The grantee, you have a grantor is a seller, the current owner, the grantee is the buyer, the new owner. So you want to look at the grantee and you want to see how they're listed and you want to print their name the way it's spelled. So if it's Jonathan D. Lack, you don't want to put John Lack on there or Jonathan Lack, you want to put Jonathan D. Lack. You want the seller's name to match the deed. Now there's a couple of provisos here. Look at the deed if it appears to be some type of partial interest. And this doesn't happen often, but I don't want them to say, I looked at the last deed and it said this. So look at the deed. If it appears that it's only a partial interest, then maybe go back a deed. Again, the property appraiser will have this little mini chain of title. So you can click on 2 or 3 deeds, make sure you have a picture of who the current owners are. But the way their name is spelled, that's the way they're entitled. That's the way the contract should be prepared. The other piece of that, I'll get to legal description in a moment, but legal description is again off of the deed, not the property appraiser's little shortcut, but the deed. When I get to legal description, I'll discuss that a little further. Always be aware that you have all of the sellers. So again, when you look at this last deed, and one of the areas, the property appraiser, this happened to me many years ago in the 90s in South Florida, it was my own property. There had been 3 people entitled to the property. And when my wife bought it, and it ended up John, Donna, and whoever that third party was, because the property appraiser never cleared the field of the third party. So the property appraiser made it look like we had a partner in this when we didn't. It was just whoever the clerk was back then didn't clear the fields. So again, the clerk of the property appraisers, they do a great job. I've talked to Dana Blickley and she's great, but you want to go off of the public record, the deed, not what somebody else might have typed. So you want to look to make sure you have all of the names that are there. And if you're missing a name, in my case, if the property appraiser says one, then the other thing, I have a new employee, Linda, and welcome, Linda. She's here attending the class as well, and she's part of the growth of Waterview Title. And she's already heard me say this. If you see a discrepancy, figure it out. Don't just say, oh, that's not right, and then move on. Say, that's not right, let's figure out why. Ask your seller, who is this third person? Oh, that's my brother. He's off in South Africa, but he doesn't matter, don't worry about him. Well, he does matter if he's in title. So you do need to know the names of the parties in title, and you need their signatures. If you had husband and wife and brother, and husband and wife signed the contract, and you go to closing, and they want to get out of the deal, brother says, I never agreed to sell my interest, it could kill the deal. If you don't have all the owners agreeing to sell, then you got a problem. I just want to see what my screen, okay. So with regard to trusts, estates, corporations, LLCs, things of that nature. Again, what you're putting there under parties is the name of the party that owns the property at the time you're doing the contract. If it's in an estate, then it depends. If the estate has been opened, you put the estate of so-and-so. If it's already been transferred to the heirs, then it would be, if it's a probate, if it's a homestead property, for example, it descends to the heirs as of the date of death. So again, you might have to speak with your seller and confirm how it's supposed to be entered, who the seller is, but that's who needs to go on the contract. So again, if you're in a probate situation with a homestead property, you need the heirs to be the ones to sign it. So I kind of went a little further afield than I intended to on that. If you have questions on that, again, I'm always available to answer them, but the seller is, again, as it's on the deed. Marital status and homestead, I apologize for my bouncing around in my head. I usually do the buyer first, and I decided to do the seller first today, and it's messing me up. so we're keeping on track. The seller. Marital status. In the state of Florida, the Florida Constitution, it's Article 4, Section 10 or Article 10, Section 4. I always get those mixed up, but it is the Florida Constitution provides that no person shall convey or encumber, so that's sell or mortgage, homestead property without the joinder of their spouse. It's a constitutional provision. It's non-negotiable. Just so you know the history, it arises out of an 1896. Women could not own property, and there's only a couple of guys in the room here, but we were the only three of us. We're the only ones who were allowed to own property. You guys could not own property back in 1896, and we're scoundrels. We're bad dudes, and we'd gamble. We'd go to play a game of poker and throw the deed in, and oh shoot, we lost it, and now the family ended out on the street. So the state of Florida said we can't let that happen. We can't let these scoundrels be losing homestead property and having wife and children out on the street. We're going to pass a constitutional provision that says you can't lose your homestead without the joinder of the spouse. So even though women could not own property, they still had this homestead protection, so they could not be kicked out of it. You did get the right to own property in 1968. So I think we're all good now. You guys can own property, yay. And if you were a free dealer, you could own it before then, but that predates me, and I've never understood what that meant. So, so when doing the contract, you do not need to put marital status, okay? But when doing the transaction, we're going to need, as a title company, we're going to need to know the marital status. And if it's homestead property, the spouse is going to have to join. So again, by way of example, I can own a property in my name alone. Donna may not be on title. So I own it. She's not on title. I bought it before we got married, maybe, and now we're married, and now we live in the property and we want to go to sell it. She has to join in on that. It's my property. I own it. She might not even be entitled to any proceeds, but she has to join in on the sale of that property. And if we're separated, if she's, if we're there in the state of Florida, there is no legal separation. You're either married or divorced. There's no middle ground. Yes or no. If you got married, you got to get divorced. And if you haven't gotten divorced, you're still married. And if you haven't talked to your wife in 8 years and she's living in Montana, so be it. You need to hunt her down into Montana, because you cannot sell your homestead property without the joinder of your spouse. It's absolutely non-negotiable. So be aware of that. And again, you don't have to put marital status on the contract, but it might be helpful if you put John Lack, a married man. That way we know, hey, we got to hunt down Donna. Or if it's not homestead, we can put on the face of the deed, the property's not homestead, and we're good to go. But we have to address it. It cannot be ignored. So that's what the marital status and or non-homestead status is. Other things regarding, no, that would be regarding the buyer. So let me get to the, so that's pretty much the seller. The seller is the easy one. And I took that long to do that, but the seller is the easy one. You look up the deed, assuming there's nothing weird with partial interest, and the last deed is a warranty deed from a prior seller, and it has John and Donna, husband and wife, it's very easy. And the important part is that you just spell their names properly. The reason I emphasize the spelling names properly, which I'll get to with the buyer especially, is we, title company, take what you give us contract, plug it into our computer. You take the contract, you send it off to the bank, they plug it into their computer. If there's a misspelling, it's going to be propagated. And if it's the seller side, I ought to catch that. If you made a mistake on the seller, when I do the title work, I should see the deed and say, oh, the name's spelled wrong. And Linda here is going to call and say, hey, what's the proper spelling of the name? We got to get it right. So as a title company, we're going to deal with the seller side. Now I'm going to finally make my transition to the buyer side. So buyer's name, I always say, try to make it match the loan application. So many buyers now are getting pre-approvals. Obviously, if it's cash buyer, different scenario, but so many buyers are seeking a pre-approval. And so they're pre-applying to a bank. Sometimes they do Jonathan Douglas Lack. They use the whole name. Sometimes it's just Jonathan Lack. They leave off the D. I'm Jonathan D. Lack. That's how I sign, and that's how I, that's my name. And the buyer should do it the way the buyer wants. I always advise that you do your name as you sign. The reason for that advice is when you get a bank loan, you're going to be signing your name about 100 times. The bank insists upon you signing your name as written. Now, I used to fight in my youth. In the 90s, I would fight with the banks. That's not their signature. And clients would say, that's not my signature. I signed it Jonathan Lack, not Jonathan D. Lack. I gave up the fight. He who has the gold makes the rules. The banks want you to sign with the D, you sign with the D. So if you're not used to using the middle initial and you're sitting across the table from me at a closing, I'm going to be saying, don't forget the middle initial. Don't forget the middle initial, or leave it off, leave it off. And it's hard to leave it off if you're used to putting it in there. And the banks, again, I disagree with it legally. Legally, your signature is your signature, and I don't care what it says. That's my signature. But the banks are the ones who decide this. So try to make it match the loan application so it's easier, so that it matches, and have the people apply the way they sign their name. Now, the proviso there, if you have a common name, if it's John Smith or Maria Garcia in South Florida was the record holder for the number of judgments back in the 80s, actually, in that case. But if you have a common name, then use at least your middle initial or your full middle name even. And yep, you'll have to sign Douglas. You know, I don't even know how to spell Douglas because I'm not used to signing that, but you'll have to sign and spell the whole name. But if you have a common name, the way title works, it's called a grantor grantee index, and we search names, and judgments against your name can be a lien against the property. That's what title insurance is about, confirming there's no liens against the property, which means no liens against the seller. Well, if you have a common name, if your name is John Smith, there might be a lot of judgments against John Smith, and none of them are you. And as a title company, we have to go through and verify each one. So at least if you're John Xavier Smith, now we can look for, you know, if it's any other middle initial, we can discount that and shortcut our title search at least. It doesn't help when there's no middle initial, but it at least makes it a little easier, and it's easier for the owner. Obviously, I care about the title company, but the owner's gonna have to go through this for their whole life. So again, I would use a full name in that scenario. So in the old days, you'd show up in somebody's kitchen, you know, you'd sit in their kitchen table and you'd handwrite a contract. So some of my notes are related to that. One of them is be legible. If you're actually writing it, print it. Don't use cursive, because different people's cursive, if people are even still using that, looks different. Sometimes ours look like S's and these look like A's, and you can't tell what's what. So make sure you print, and make sure, again, it's very legible so that A's look like A's and O's look like O's, and we're not trying to guess what the letter is. Because again, as a title company, we're just gonna plug it into our computer and move forward from there. I already discussed as they sign, correct spelling. I'm Jonathan, but I go by John, Jon, not John. So again, it would be Jonathan spelled out, but John can be spelled differently. Stephen can be S-D-E-V-E-N or P-H-E-N. Kathy could be with a K or with a C. There are so many variations and so many different names and variations of spelling of common names. So don't assume you talk to John Lack and put J-O-H-N. Confirm with your client what their actual name is and how they spell it, and make sure you get the correct spelling on there. And that's 1, 2, 3. And marital status, we already covered. So marital status for the buyer side, you don't need it, again, if they're getting a mortgage. So if I'm buying a property alone and it just says John Lack there is the buyer, and then I show up at the closing, and again, this is a live scenario from a long time ago, but I went to a closing and I'm sitting there across from a gentleman, and I notice his wedding ring, and I'm like, oh, that's a very nice ring. Where's your wife? Oh, she's off in the Bahamas. I'm flying out to see her as soon as we finish this closing. I'm like, we're not finishing this closing because your wife is in the Bahamas, and you cannot mortgage a property. Remember, we went back to the constitutional thing. You cannot mortgage homestead property without the joinder of your spouse. So if you're a buyer and it's homestead property, even if you're buying it in your name alone, if you're married and it's intended to be homestead property, your spouse will have to join on the mortgage. So even though the spouse will not owe any money and she will not be a borrower, she still has to join in for this constitutional provision. So we need to know buyer's marital status as well, because if it's homestead property, the spouse is going to have to join. And the goal of this seminar is for you guys to get to a smooth and successful closing. That's what we're here for. That's how you get repeat business. That's how the client leaves happy. Transactions are going to get bumpy along the way. There's going to be issues, but if we can finish it off with a smooth closing, it's all good. If it turns out we get the closing in that scenario with the guy with the wife in the Bahamas, not so good. And this was back in the 90s. We actually were able to fax stuff over to them and have them FedEx it back to us. And we were able to get it done the next day, and it worked out okay, but it's, you know, not ideal. It would have been better to know in advance that this gentleman was married. So other pieces of the puzzle with regard to the buyer. If you're doing something like a father and daughter or a mother and a son, it doesn't hurt. The contract is all about clarity. The goal is that everybody understands what they're doing and we all do it right, so we get to our smooth closing. So you don't have to say Donna Lack and Sam Lack, you know, father or mother and son, but it's not a bad idea to either say it or somehow make sure the parties know it, because sadly it will happen. If you put Donna Lack and Sam Lack, somebody is going to think, oh, husband and wife, and you just married a mother and son, which is kind of disturbing. So again, we don't want to have that happen. And likewise with fathers and daughters or brothers and sisters, all sorts of things. Make the facts known to the next participant, the title company, the lenders, et cetera, so that we get it right. And then lastly, confirm how multiple owners to hold title. I'm going to give you a brief lecture on multiple owner title. This is again for you to have in your head, not necessarily for you to have the conversation with the client, but for the client to be aware of it, to advise the title company, and the title company ought to ask how they want to be in title, which I'll explain in just a moment, but not every title company will do so. So I want you guys to be aware of it. So when two different people own property together, there's basically three options. There's a few others, but three primary options. If they're husband and wife, the default, so if it just says John and Donna, husband and wife, or even if it doesn't say husband and wife, if we are in fact married, the default is what's called tenants by the entireties, that TE there, tenants by the entireties. And it treats the husband and wife as a single entity, as an entirety. So the husband and wife is one entity and they own it together, and there is a right of survivorship, which I'll explain in a moment, but if husband dies, wife still owns the entire property. Wife dies, husband dies. There are some other legal protections available to the husbands and wives. So tenants by the entireties is valuable. I won't dive into that piece of the lecture, but if you're not a husband and wife, again, man and woman, brother, sister, two investors, whatever it is, the main choice is, the default is what's called tenants in common. So John and Jeff, that's my brother. So John and Jeff own the property together as tenants in common. If I die, my share goes to my heirs, to my children or wife, and his share goes to his heirs. So they're separate but equal, and actually in tenants in common, they don't actually have to be equal, but separate but equal. But I die, it goes here, he dies, it goes here. Now, it goes pursuant to my will. My estate will have to be probated. It'll have to determine who my heirs are. So if I die, we have to have a probate process to determine who gets it, and whoever gets it can share it with Jeff. Now, it's possible in my will, I give it to Jeff, but my will still has to be probated to give it to Jeff. So that's called tenants in common, and it's very commonplace. It is the default, and it's what would happen when two unrelated people typically would take title. That's how they'd want it to go. It happens a lot with second marriages too, where they might want it different. So again, it's a common type of ownership. However, it is very frequent that people want what's called the right of survivorship. Joint tenants with the right of survivorship is Jeff and I own it, but if I die, this is an investment between us, and if I die, he automatically owns it. As of the date of my death, we record my death certificate, Jeff owns the property. If he dies before me, I own it. His heirs have no say, and my heirs have no say. I die, it's his, he dies, it's mine. And it's called joint tenants with right of survivorship. And a lot of people want that, but they don't know they want that. They just maybe think that's what it's going to be. If you don't specifically say joint tenants with right of survivorship, then it is by default tenants in common. And I get the call a year later when unfortunately one of the people dies and they go to sell it and we realize we have to have a probate. Wait a minute, I own it all. No, not only don't you own it all, but you now share it with 7 kids, that kind of thing. And it can get very messy. So that might be the intent and that's great, but confirm with owners how they want to be entitled. And again, I don't expect you to have that legal conversation with them, but refer them to me. The title company should be able to explain it. But if you just ignore it, it's not any negligence on your part. It's really unfortunate for the parties to not bring it up and maybe bad for the title company not to recommend something, but it can have unexpected consequences in either direction if you do it wrong. So that is parties. And where am I on time? And I'm already running late, but that's okay. I'll catch up. So any questions on parties before I move on to property? Yes, ma'am. Mm-hmm. Well, all right. So if you wanted to say, I think I'd put tenants in common because I'm not sure, I abbreviated that as much for me as anything else, though those are kind of standard abbreviations, but usually there'd be a slash there or something. But in any event, really for the contract, you don't need to put it. But there's no harm in it. If you want to put tenants in common, that way the title company knows that's the intention, or really more importantly, if you want to put joint tenants with right of survivorship, and there you could put the JTROS, that's fairly common abbreviation. That way the title company knows that's how you intend to do it. But really this part of the lecture isn't so much for what you actually put on the contract, but for you to be aware that this is an issue. So when you're talking to the parties and when you're talking to the title company, be it through an email or verbally or otherwise, you communicate the fact of the question. So if you want to put it on the contract, that's great. As I say, anything you put on the contract that is accurate is valuable. If you put John, a married man, that's a great thing because now I know, and now I know to either confirm non-homestead or get the spouse to join. So putting that is valuable, but it's not legally necessary. Putting tenants in common, it's just adding valuable information, but it's not necessary. What is critically important to take away from this, though, is don't guess and don't put misinformation. Because if you put John as single man and it turns out he's married, that's when it can hit the fan. Because now if we discover he's married, then it could be a problem depending on the spouse and all of that. And worse, if we make it all the way through closing without discovering he's married, and then it goes into foreclosure and the wife never joined in on it, then you have an issue. The wife can argue that you can't sell the property, and there are cases out there of that nature. So misinformation is dangerous. So be careful what you put, make sure it's accurate. But provided it's accurate, putting tenants in common or joint tenants with right of survivorship or a married man or a single man or woman, et cetera, is perfectly, I mean, it's a good idea, but it's not necessary. I want you to be aware of these issues so that in the course of your dealings, you're communicating with both your clients to say, hey, you two are buying it. Are you buying it together as tenants in common or joint tenants, or you need to speak with John, or you need to talk to the title company just to understand. The main thing is this right of survivorship. Either it exists or it doesn't. And that's a significant thing. Right. And then, yeah. Mother and son. Perfect. Yep. But so, and if I don't mention anything about the tenants, which is tenants of right. They assume, or when they so okay, so great question. And I'm sorry for those in Zoom. The question was if you put husband and wife, or if you put mother and son, if you don't ask whether it's tenants in common or whatnot, what happens? And the answer is, if they're married, if the fact is that they are married, then the default under the law is tenants by the entireties, which means a right of survivorship. And that's a good result. If they're not married and you don't state it, the default is tenants in common. And I don't want to say it's a good result or bad result. It's a completely dependent. It's what the state of Florida has decided is the default, and that's probably the correct default. But if you want right of survivorship, you better say it. So that's really the point. If you don't say anything, it's going to be tenants in common. If the title company's on the ball, they'll probably ask because it's a significant question. But if they're not on the ball, they're not negligent. It's not their job to ask that question. I'm always going to ask it, but not everybody will. And if I forget and don't ask it, I didn't do anything wrong. But if it ended up tenants in common and they wanted right of survivorship and somebody dies, there's going to be unhappy people. So the default is tenants in common, to answer your question, if you don't say anything and nobody inquires. So yes, sir.
So just to clarify on the seller, let's say the seller is the wife, but if she bought the property by herself, now they homesteaded it. So when does the husband, what documents do does the husband actually sign?
Okay, so again, the question for those in Zoom is, if you have a woman who bought the property before they got married, or even they were married, but she bought in her name alone, and now they're going to sell the property, the mortgage or convey. So signing a mortgage, spouse has to join on homestead property, whether they own it or not. And signing a deed, the spouse has to join in on the deed, whether they own it or not. Homestead property, spousal joinder is the terminology. So if you're married, your spouse must join on a deed or must join on a mortgage. Now, if I will tell you as a complete aside, and a part of the legal work of my world, if you have two people who bought it, say fiancés, I get that a lot. You get fiancés who buy it because they buy the property before they get married. I highly recommend that they call me after they get married and create a tenants by the entireties, because there is a special thing only available to spouses, but it doesn't happen when you get married. If you're married when you take title, it's automatic. But if you take title before you're married and you get married, it's not automatic. You have to create tenants by the entireties. So you have to record a deed from John and Donna, husband and wife, to John and Donna, husband and wife. It looks very silly. But the idea is, and I always put on the face of the deed, the intention of this deed is to create a tenants by the entireties. So that's a separate step you would want to take if you bought it. And now again, I buy a property in my name alone, I get married. Sometimes I don't want to put the wife on title. I want to keep it in my name alone. There's nothing wrong with that. But if it's homestead property and I go to sell it, she's got to join in. If it's rental property, it's mine. She has nothing to do with it. So again, all of these are fact-based questions, but I want you to be aware of the existence of the questions, whether you ask them or not, at least be aware of them. And the one I really want you to be aware of is spousal joinder on homestead property, because you need to know that the spouse has to be there. And if you know the spouse is in Europe, then you know we need to work out some remote notary to get that document signed, because we can't close without it. Yes.
So I bought my house as a single woman. I've gotten married. I've changed my last name. Decided I don't like my husband, and I divorced him. But it's been homestead the entire time. Even though my divorce papers say I own the house in its entirety, since it was homestead, we have to join on the deed myself.
No. Okay. So again, the question for Zoom: bought the property pre-marriage, get married. Did you deed the property to yourself as tenants by the entireties, or it stayed in your name alone? Okay, so you buy it in your name alone, so single woman, then you get married. Again, like I just said, getting married does not create tenants by the entirety. So you're still in title alone. The spouse, if you were to mortgage or sell it, the spouse would have to join. You get divorced. You're no longer married anymore. That's what divorce does. So you're no longer married. You just own it in your name alone. And it doesn't matter if it's homestead or not, because you're a single woman. So you can sell it without the joinder of your ex, because he never came. What's that?
Even though it was his homestead?
It was, but if he wasn't in title, then once you get divorced, it's not his homestead anymore. Again, the question for Zoom was, because while they were married, it was homestead, does he have any rights? Once you get divorced, his rights get cut off. While you're married, he has rights. The minute you get divorced, it sounds awful, but it's as if he predeceased you. He doesn't exist anymore once you get divorced. That's how it applies to your will too. If your husband is in a will and he dies, you get divorced, he's extinguished from your will. So things like that. I better be careful in that statement because I'm 99% sure it's true, but there might be some recent laws that I'm not aware of. So scratch that just in case, though I think I'm right. But so the answer is, it's at the time of the conveyance, you're either single or married. If you're married and it's homestead, your spouse has to join. If you're married, it's not homestead, we don't care. Your spouse doesn't have to join. If you're single, we don't care because you're single and you can do whatever you want. So, but it's at the time you're signing the document. So if you got divorced yesterday, you can sign it today. If my divorce is going to be final tomorrow, then either the spouse has to join or wait till Wednesday, kind of thing. So, all right, I think, let's see, I had one Zoom question. What happens if a married woman buys investment property and it is not homestead? Does the husband need to sign when she sells? No. So again, homestead is the key. If it's not homestead, you can do anything you want, married, single, doesn't matter. But beware, I won't say beware of fraud, but be careful, so, oh no, it's not my homestead. Yeah, well, then why do you need a moving truck to get out before closing? So again, and homestead, I'm overkilling this a little bit, but what the heck? Homestead, there's two types of homestead. We're talking about the constitutional protection for spouses. And homestead is defined as your principal primary residence. It's a matter of intent. If you live there or even intend to live there, so you're buying it to be homestead. So if you live there or intend to live there, that's your homestead for constitutional purposes. It is not the same, though it's related in philosophically, to the homestead tax exemption. You guys want to file for the homestead tax exemption because it reduces your tax bill and it adds evidence that this is your homestead. But the fact that it does not have the homestead tax exemption does not mean it's not your homestead. It just means you didn't avail yourself of a tax break that you could have. So the fact that somebody fails to file for the homestead tax exemption does not alleviate the constitutional piece of the puzzle if they in fact live in the property. So tax version, constitutional version, related but not the same. One can be evidence of the other, but it's not evidence that the other doesn't exist. So, all right, in the interest of time, I'm going to move on to property description. So where am I on time? Okay, oof. All right, property description. First line is really easy. Street address. You probably know the address of the property you're doing. My only request as a title company is please put the zip code. The street address is solely for postal purposes. It has no legal bearing, and I'll get to that in a moment under the legal description. But while it has no legal bearing, it is still valuable and necessary. We have to have an address on the deed, and if you're sending people mail, you have to have a zip code. And while you're doing it, you probably know it. Now, Palm Bay has 32905, 32907, 32909. I know most of which ones they are, but not always. Melbourne with 32935 and 32901 and 32904, I think, is West Melbourne, though I get confused on that one. So I know a lot of them, but I don't know all of them, and I might not know which it's in. And the zip code matters. So please put the zip code. That's my only request on that. Now, B, property located in, again, Brevard County, presumably, if you're doing Indian River or Orange County or Broward County or wherever you're working, that's the county. Property tax ID number, that should be either in Brevard County, and it's one of the few counties that does this, but in Brevard County, we have a tax account number and a parcel ID number. The property appraiser has the parcel ID number, which is the 243628 1*8 or whatever. It's a long string, and it's on the Brevard property appraiser site. That's the parcel ID number. There's also a tax account number. The Brevard County tax collector has usually, I think it's a 6 or 7 digit number, 279586. And that's the tax account number. The purpose of putting this here is to clearly identify the property that we're intending to sell. And it doesn't matter if you put the tax account number or the property ID number. Just again, same as always, be accurate with whichever you put. I typically put both because that's just who I am. So I pull them up both and I put them both and the computer lets me do it and we're cool. But you don't need both, you just need one. Most counties just have, the other term that's often used is folio number. So sometimes you'll see folio number, sometimes you'll see parcel ID number, tax ID number. All of those are the same. The purpose here is merely, we're under property description to describe the property we're selling. Now, I'm going to come back to tax ID number in a moment, but I'm going to jump to my favorite part of all of this is the real property legal description. What I love about, I do title insurance. What I like about real estate, what I like about title is the land we're standing on, can be legally described. So right where I'm standing right now, a surveyor can come out and tell me exactly where I'm standing. And then I can tell you, everybody who has owned this piece of land, carpet that I'm standing on, not the carpet, but the land underneath it, from the Queen of Spain in 1827 ceded it to the United States by treaty, and then the United States created the state of Florida in 1845, and then the state of Florida started parceling it out and selling it and homesteading it and all of that good stuff. So I can tell you everybody who's owned this property since the Queen of Spain till now, and it's done via legal description. That's how we do it. So I'm just going to stick to the state of Florida for now. When the United States created the state of Florida, they mapped it out. And they mapped it out with what are called sections, townships, and ranges. You might have learned some of this in your real estate classes, but the punchline is a surveyor can draw out describing what the property is. There's two types of description. There's what are called a meets and bounds legal description. And that's when the surveyor comes and says, start at the American flag in the southeast corner of the lot, and then go north 100 feet to the fire extinguisher, and then go west 75 feet to the light switch on the wall, and then go south to the exit sign, and then come back east 73 feet, because it was at an angle, back to the American flag point of beginning. And that's what's called the meets and bounds legal. And sometimes they're a lot longer and they're very messy and they're a lot to type. So punchline to all of that, don't sit there and try to type all of it. The property appraiser will usually condense it. You can cut and paste the copy appraiser part if you want, but this is where having the street address and the property ID is so important because you're tying it in. And what I do when it's truly a lengthy legal description, if it's short enough, I'll type it. If what I just said, I might type that. But otherwise, put in there per deed recorded in. And remember, I told you to pull up the last deed of record. That's how this seller owns it. He owns what he bought. He bought what's on the deed. So you're allowed, the deed is a public record. So legally, you can refer to public records by reference, and it's legally a part of the contract. If you say per official records, deed at official records book 1, 2, 3, 4, 5 at page 78 of the public records of Brevard County, Florida. And again, you can shorten that a little, but if you put the deed book and page by reference, that's the property we're selling, because that's the goal here, is to sell the property we're selling. The good news is this conversation in this contract is for residential property. So most residential property, some developer came in and bought that legal description that I told you, but that was this whole room. Now they're going to subdivide it and create a subdivision, and it's going to be the SCAR subdivision, and they're going to draw what they call a plat map, and they're going to make each desk or each table here is going to be a block, and each chair at the table is going to be a lot. So Linda's sitting in lot 1, block 1. I'm sorry, I didn't catch your name, but 1, 2, 3. You're in lot 2, block 3, etc. And you can legally, once that gets platted, recorded in the public records, approved by the county, all of these streets, all of the easements we needed to get you electricity are all drawn on the plat, so that this room is now a subdivision, and those are your lots and blocks with all your roadways. And now that chair, lot 1, block 1, I know Linda's owned it since the beginning of time now, and I can search it from that forward. When they plat it, some title company had to make sure that the developer owned the whole area, but once they platted it and created the plat, now we can just search lot 1, block 1, etc. So again, you can look on the property appraiser, and these are the easy ones, and that's the ones we usually use, is it'll say lot 1, block 1, SCAR subdivision, plat book 2, page 10. So you put that on there. So the things to be wary of. Sometimes people will buy two separate parcels, lot 1 and lot 2, separately. So there's two separate deeds, two separate tax ID numbers, but they built the house right in the middle of both of those lots. Or they built the house here and have a vacant lot here. Let's go with that scenario. Built my house, have my little park setting next to my house. Okay, so I come to you to sell the house, and there's so many scenarios here. I'm going to try to hit all of them. I just want to sell the empty lot. I need some money. I have my house. I was keeping the lot, but I need some money, and the prices are so crazy right now. I'm going to sell it. So, all right, I messed that up on that scenario. All right, rewind. So the scenario, I'm sticking with the scenario, a house and lot, but I bought them together. So when I bought it, I bought the house and lot together, lot 1 and 2 of Happy Acres, right? So I bought them together. I have my house, I have my lot, and now I'm going to sell. I've told you guys to look at the last deed of record. Well, the last deed of record says lot 1 and 2 of Happy Acres. Well, we're only selling lot 1. My house is on lot 2. I'm selling lot 1 for $10,000. If you put on the contract lots 1 and 2, because you listened to me and you copied the last deed of record and you weren't paying attention, then you just sold their house and lot for $10,000. So really bad idea, really be careful. The flip side is that first scenario, I bought them separately, but I built the house in the middle or something. And you just grabbed the last deed of record and it just said lot 1. It didn't say lot 2 because that was a separate transaction and you didn't do a full title search because that's not your job. So now you've just sold either half the house or maybe the empty lot and the house, not the house, etc. So be very aware when you visually are at the property and it looks like a double lot. That's your first clue. If you're talking to the party, are we selling both? Or are we just selling one? If you see a deed with multiple lots, again, I finally sold it, yay. But my old office on A1A was this tiny little strip in Indialantic, but it was 4 lots. They were 25, it was 100 feet wide, but they were 25 feet lots. They allowed that back in the day, I guess. And so my legal description was lot 1, 2, 3, and 4 of Indialantic instead, and you would look at that and like, that's not 4 lots, it's one tiny little house, right? But so be it, that's what it was. So it's not, sometimes you'll see that. Again, going all the way back to the beginning, if you see something, a discrepancy or something you're not sure of, figure it out, don't ignore it. If you see multiple lots, confirm that it's the right thing. If you only see 1 lot and it looks like 2, maybe you missed a deed, maybe you list a lot number. Then the other proviso to that scenario is sometimes there's 2 tax bills. If we bought them separately, you can combine them in what's called a unity of title, and then the tax collector will only give you 1 bill. But if you bought 2 lots separately, unless you do something constructive, they will continue to bill the 2 lots separately. And if you don't, again, these are weird scenarios, but if you don't tell the buyer that they have 2 tax bills and you do it, they might only pay the 1 tax bill. They might get the other one, but they know, people do dumb things. They might not pay attention. They might miss it. Maybe the bank doesn't get it into their records. Next thing you know, the empty lot got sold for a tax deed because nobody was paying the tax bill. And again, these are live scenarios that have happened. So I'm not making up stories. These are the one that I got involved in years back, and we ended up thankfully resolving it by good negotiation. But the gentleman was selling a building and the parking lot, but the buyer didn't know about the parking lot, and it ended up going to a tax deed. And so it was a commercial structure and he lost his parking lot. We were able to buy it back and it all worked okay. Again, I was involved after the fact, not on the front end of that, just to be clear. But so be aware if there's multiple parcels, whether it's 2 became 1 or 1 is becoming 2, whatever the fact scenario, this is the warning I want to give you. And what you put on the legal description, again, be accurate with the lots, whatever they are, the subdivision name, the plat book and page. You can abbreviate like the property appraiser does, but be wary because sometimes the property appraiser will truncate something and you might miss it if it's a lengthy legal. So that's why I say with reference to a deed. And I think I've covered that. So let me see if there's any questions there. Okay, so continuing on this front, the other point, so the real property is the land that we've just legal described, plus the existing improvements and fixtures plus the built-in appliances, built-in furnishing, attached wall-to-wall carpet and flooring. The contract is not me saying this, the contract the parties are signing is saying this, that it includes the building, obviously, and any other fixtures. Fixtures is a hard legal conversation, so I'm going to keep it short and simple. If it is something that causes damage upon its removal, presume it to be a fixture. So if I have to move something and I'm going to leave a hole or I'm going to leave some damage when I do it, then it's probably a fixture. And if there's a question, you should clearly negotiate. Are the solar panels on the roof a fixture or not? Probably they are, but don't leave it to question, put it in the contract. They're included, they're not included. Again, if you're clear, you don't have a problem later. If you go to the walkthrough and they've pulled off the solar panels, A, probably left holes in the roof, so that's bad, but B, you're probably going to have an upset buyer who thought he was getting solar panels. And then whether you have a legal fight over whether that was a fixture, there's a lot of case law on fixtures. So that circles one of my early conversation that I didn't have. People call me all the time, what is the law on this? What is a fixture, or what is the law on something? For your transaction, this is the law. What you do on the contract is what the judge is going to look at. Judges look at the four corners of the contract and they determine who's right and wrong based on that. Now, there are some Florida statutes out there that cover some issues, and there's case law when people have fought. The way our legal system works is precedent. So if a judge has ruled one way, the next judge is going to usually rule the same way. So it is all fact-based, but it's based on precedent. So there will be case law that will answer fights, but this is what the judge is going to look at. So this is the law of your transaction. So if you make it clear, solar panels included, now there's no fight to be had. If you leave it off, now we're okay, is it or isn't it? Well, this judge said it was. Well, this judge said it wasn't. So now we got to find out what our judge says. So the other comment I make, you never, ever, ever want to be in court ever. I have gone to court. I do, but I don't anymore. I opened with, I'm changing my practice. I am focusing on title insurance. I am focusing on growing Waterview Title. So there's my second pitch, I guess. But I do legal work, and I have gone in with, 90%, we're going to win this case, and you lose. And then we have no shot at winning the case. We're lucky. We really shouldn't even be here, and we win. It depends on the judge. I'll be prepared. I'll always argue. I always tell my clients, would I rather be you or them before I take a case? I'd rather be them, but if you want to fight, we have an argument, or I'm glad we're us. But even when I'm happy to be on my side, if the judge had a bad day, if they got in a fight with the spouse, the dog messed in the house that morning, any of those things that put the judge in a bad mood, they can rule any way they want. They're very fickle creatures, and they don't always rule the way you think they're gonna. So then you can appeal it if you think it's wrong, and you can spend thousands and thousands and thousands of dollars fighting over $100 deposit. So you don't want to go to court. You want to resolve it. You want to settle your cases, and this is going to be the best way to do it. Get it right out of the box. So that's that. Personal property. If you look on line 16, it's personal property unless excluded, which we'll get to in a moment. The following items which are owned by the seller and existing on the property as of the date of the initial offer. That's significant. If I walk in and I'm doing you're having an open house or you're doing a showing, and I walk in and I see the Sub-Zero refrigerator and the Wolf appliances and these beautiful chandeliers and ceiling fans, and wow, this place is gorgeous, and here's my offer. And then I go back through and have my walkthrough before closing, and you've replaced the ceiling fans with single light bulbs like in a prison, and you've replaced the appliances. You went over to Costco for that great sale and you took your good appliances out. You don't get to say, it says refrigerator, I gave you a refrigerator. No, it's the refrigerator that was there at the date of the initial offer. It's the ceiling fan. So a bunch of little examples here, but my background is I was actually a math computer science major before I went to law school. So I always think of computers, and hard coding is the word I use. And they hard coded into the contract the following items: ranges, ovens, refrigerators, dishwashers, disposals, ceiling fans, etc. You guys can read it. You'll note there are S's after some of them, such as refrigerators. Some people have a garage refrigerator as well as the regular refrigerator. If you have a garage refrigerator and you're planning on taking it with you, you need to make a note of it, because if you sign this contract, existing, owned by the seller, I own that refrigerator, it's on the date of the initial offer, and it says refrigerators included. So you just sold your garage refrigerator. So if you take it away and the buyer wanted it, then you're in default. Again, I'll circle back to that as well. It includes the light fixtures. So if you have your heirloom chandelier and you're planning on taking it, make sure you exclude it. You don't want to just take it. You want to make it clear that you're going to be taking it so you don't have a fight later. Again, I jumped around unintentionally, so I'm going to slide on back to line 21, other personal property items included. That's where I meant to be. You'll note in the hard coding, it doesn't list washer and dryer. So I don't know why they chose not to list the washer and dryer, but they didn't. It turns out a lot of people take their washers and dryers. I guess those are more personal than the other stuff. And you know, some people don't want them, some people do want them, whatever. But the punchline is, if it's not listed as a seller, I don't have to say it's excluded because I did not include it. As a buyer, if I want the washer and dryer, I need to include it because it's not included. Again, I've been doing this for 35 years. I have seen several dozen realtors buy washers and dryers for their buyers because it wasn't in there. They go to the walkthrough, the washer or dryer is gone. I can explain it all day long how, you know, you should have had me review the contract and, you know, it's not your realtor's fault and blah, blah, blah. You know, it was never included. You should have included it. But the punchline is, to make the deal go, to earn your commission, you end up buying a washer and dryer. And it happens, like, not a lot, but again, several dozen times in my career. So once a year, maybe, pretty close. So if the washer and dryer is intended to be included, make sure you put it. The other thing I see often is pool equipment. So again, if you got the little creepy crawly and all of that, if the buyer is buying, a seller is buying a house with a pool, they're probably going to take their pool equipment. If they're not, they might be willing to leave it. Don't leave it to chance. If you expect the pool equipment to stay, list the pool equipment. If you don't expect it to stay, then you don't have to say anything. We're good. And so my note then says, list items that could be removed but are expected to stay. So if it's not already listed, washer and dryer, and they can be removed, but as a buyer, I want them to stay, you need to list those items. Now, the excluded, the following items, paragraph E, line 24, the following items are excluded from the purchase. There, list any items that will be removed. Again, you can put washer and dryer in there if you're planning on taking it. It's not necessary to do it because it was not included to begin with. But for clarity, so that there's no fight at the table, when the buyer signs it and sees that it's excluded, they can't then make you buy them one. So it's not a bad thing, but it's not necessary. What is necessary is the chandelier. If you're planning on taking the chandelier, you need to list that. If you're planning on taking the garage refrigerator, you need to list that, because it is included in the contract unless specifically excluded. So list any items that will be removed, and then you'll be safe. So I think I hit all my notes. I did. All right, with that said, yes, go ahead.
So in the line 17, it says they don't want to be a substitute refrigerator. And they have a refrigerator here with cross.
Right, if it's, well, it's you, all right, so the question is, if you're gonna take stuff out, do you cross it out in paragraph D? And you can cross it out and initial it, but I think the better practice would be on line 24 to put that I'm excluding it and exclude refrigerator. So again, up at the top, it says, unless excluded in paragraph E, the following items are included. So if you exclude them in paragraph E, they're therefore excluded. So I would put refrigerator or whatever you're planning on taking. Now, the other thing is, if there is no garbage disposal, again, it says owned by seller and existing as the date of the initial offer. So if it's not there, it's not there. So somebody can't say, hey, you got to give me a garbage disposal because it says on the contract. No, if it wasn't there, I don't have to go buy you one. But if it is there, I don't get to take it out without telling you. So does that make sense? Yes, sir.
Okay, so if the buyer's agent and your listing thing, and the seller's agent said that they're not conveying the pool equipment.
Right.
So I don't put that in the contract, so it's up to the seller's agent to then revise the contract to say that excludes pool equipment.
No, well, the example you used is not a great one, but yes. So the example he used was the listing agreement, this is for the Zoom folks, the listing agreement said that the pool equipment was not included. So when we do the contract, we're silent on that issue. And the gentleman was asking, does the seller need to revise the contract to state that it's not included? The reason I said it was a bad example is it's not one of the hard coded items. So if you wanted the pool equipment, unless that was your example, did you want the pool equipment? So so in that example, it's if you want the pool equipment as a buyer, you need to add it to line 21. The seller does not need to remove it on line 24 because it wasn't necessarily included. But if the garage refrigerator, we'll use that example, that is included. It's automatically hard-coded included. So if the seller wanted to remove that, garage refrigerator, in the listing agreement, and this is important also, if the listing agreement says garage refrigerator not included, right? But the contract doesn't put it on line 24. There's a very strong to winning argument that the buyer is entitled to the garage refrigerator because the contract is what controls. The listing agreement is just salesmanship. And the listing agreement is what we're offering. I mean, what we're offering for sale. But if you sign this contract, you've changed, you've accepted our offer to purchase, and our offer to purchase may include the garage refrigerator. You can reject it, but if you don't reject it, if you sign this and you accept it, the fact that you put in the MLS that it wasn't included, it's not relevant to me. I am a realtor, but let's pretend I'm not. I'm buying it for myself and I'm not looking at the MLS. I just saw the sign and I did it all by myself, and I'm not bound by the MLS. I don't even know it exists. I'm just going by the contract. So again, line 21, let me reread it, list items that could be removed but are expected to stay, meaning items that are not listed already, pool equipment, washer and dryer. I used to put microwave, but I think the word ovens, again, a tabletop microwave, if you wanted to keep it, I think you should state that. A built-in microwave, I don't think you have to. So that's one of those, use your judgment. But when in doubt, list it. And then line 24, list the items that will be removed. So those are the items that are in paragraph D, or again, you just want to disclose it. So if the seller wants to make it abundantly clear that the pool equipment's not included, you can put it there. You're not doing anything wrong as a seller by excluding it. It might not be necessary, but again, we don't want to end up in court. We don't want to end up with a misunderstanding. We don't want you, Mr. Realtor, buying pool equipment to keep your client happy. So make it clear up front that it's either included or not, and you avoid that. So any other questions? Otherwise, I think it's 10:12 on this clock. If you guys are good with an 8-minute break, I was going to try to get through the first page, but I see people getting restless. So why don't we try to get back here by 10:20 if possible? If you're a minute later too, I'll hold up, but I'm going to try to go 10:20 and see if we can get through page 1. So. for those of you in Zoom, I had just turned off the sound while I'm just sitting here, so you're not missing anything, but I'm going to leave it off, but I'll turn it back on when we start up again. And I'll watch the chat bar if anybody has any questions. Listening. We're going to get started again, or you're going to get my speed talking by the end of this. All right. Okay, Zoom. I hope you had a nice bathroom break and got petted the dog and all that good stuff. But we are going to get back started. My goal was to get through page 1, and I made it through paragraph 1. So I'm going to do my best to pick up the pace, but this is how it goes, and we'll catch up at the end. So we're moving on to purchase price. Wow, I'm only on purchase price. Okay, purchase price. Upper right corner is the total purchase price. What that is I am paying $100,000 for everything listed in paragraph 1, property description. It includes the house, the building, the land, all of the personal property except what's excluded. So paragraph 1 is what we're buying. Top line, line 27 of paragraph 2 is what we're paying, how much we're paying for all of it. So I'll get to some other things in a moment, but that's the total purchase price, including the personal property. First line is the initial deposit. So they've actually, I did want to go back, Linda, my new wonderful employee at Waterview Title Services, reminded me that the new version of the contract, when we go with the hard-coded personal property, when they revised this version of the contract, they added several things, including thermostat, those smart doorbells, smart thermostats, television mounting. So one of the issues, that has come up over the years, people get flat screen TVs now and mount them, and is the mount stay or go? So the FAR bar, the Florida Bar and the Florida Association of Realtors said, if otherwise unspoken, the mounting hardware stays. So when you take your TV, if you have one of those cool, movable mounts and you want to put it in your new house, then you need to exclude it on line E if you're the seller. Otherwise, you need to leave the mounting hardware. If you're a buyer and you don't want it there, you might want to exclude it because you have your own that you want it, and you want to make the seller pull it off the wall because you want them to deal with it, not you have to deal with it. That's perfectly reasonable. So you can exclude it, and then the seller would be obligated to remove it because part of the contract says you'll remove everything that's not staying. So again, this can cut both ways, but be aware that the thermostats, doorbells, all of those new fancy things and television stuff, read the paragraph D of what's actually included. And then what you're paying for it. Again, we're back to paragraph 2 here. The top line is what you're paying for it. The deposit. So here comes the John Lack lecture on deposit. Okay, I've done this for a lot of years. This is purely my opinion. This is not legal basis. It's just, I'll explain to you. The initial deposit to be held in escrow, blah, blah, blah. So the top line is the initial deposit. And I get the question, how much should the deposit be? My answer to that is it depends on the facts of the case. So I use 2 main examples. I have a $100,000 VA buyer, so he's borrowing 100% financing. So $1,000 deposit, which is only 1%, it's not a big number, but $1,000 deposit to 100% buyer on a small property is a decent amount of money. If the deal falls through, that they're not going to, let me step back. The purpose of the deposit, again, John Lack's opinion of the purpose of the deposit is twofold. It is to deter a buyer from walking away from the property willy-nilly. So we're going to go through it, where there's a lot of out clauses, a lot of contingencies, a lot of opportunity for a buyer to get out of the deal and get their deposit back. So I'm not talking about those scenarios. If they don't get approved for financing, if they cancel because of the inspection, there's a lot of reasons they can get out of the contract and get their deposit back. But if none of those contingencies are an issue, they get approved for the loan, they pass the inspection period, and there are no contingencies, and then they choose not to close for no legal or contractual reason, then they will lose their deposit. We want the deposit to be a big enough number that it hurts them to lose it, that they will choose to close over not close, so as not to lose the deposit. The other half of my opinion of the deposit is to compensate the seller. So we sold the property to you, we've taken it off the market, you know, we put a contingent on MLS and we're not showing it anymore and we're just waiting for you to close now. And a month goes by and you haven't closed. And so, you know, we now have to put it back on the market and we lost a month. Well, what did we lose? I had to pay a mortgage for a month. I had to pay taxes for a month. I had to pay insurance for a month. I have carrying charges. So the seller needs to be compensated. I'm not saying they need to rip somebody off or make some huge profit, but it costs them money to not sell the property. So they should be compensated for that. So deter the buyer, compensate the seller. So one of the places this has come up in real life back in 03, 04, we had a market not unlike the market we're in now, where things were flying off the shelves and buyers couldn't get contracts in fast enough and that kind of thing. So we'd have buyers who would go put, you know, they didn't want to lose something, but didn't have time to look. So they'd put 5 contracts with $100 deposit on each contract, and sellers dumbly accepted those contracts, and the buyer would ultimately pick the one he wanted and eventually cancel the others, and he'd walk away from the $100. You know, it was a cost of doing business for those buyers in that day. So you don't want to be a seller who collects a $100 deposit. What was the point in that? You're not compensated for the time you lost. So now I go back to my examples. $100,000, $1,000 deposit for 100% financer. If they don't buy your house and they lose that $1,000, it's very possible that was the only deposit money they had. They might not be able to buy another home. So they're not going to just likely change their mind and walk away from the $1,000. And if they do, compensation. If it's a $100,000 house and it's a 30-day closing, $1,000 is probably a pretty fair number for carrying charges. So even though it's only 1%, people say, shouldn't they put 5% or 10%? Well, no, if they're borrowing 100% financing, they probably don't have 5% or 10%. And the 1% is enough for a 30, maybe a 45-day closing, 60-day closing. If it's going to be more than 60 days or 60 days, even, you might want 2,000, because again, you want to compensate the seller. But flip side, you gotta, and this is a crazy live example. Again, I came in after the fact, just to be clear, but we had a buyer was buying a property for his soon-to-be wife, his newlywed, and he was a very wealthy man, and it was $1.4 million purchase price, and he was paying cash, and this was back in 2005. So it was, I want to say, August of 2005. And he's paying $1.4 million for this property. And we got proof of funds, or they, you know, I got involved after the fact, but they got proof of funds. He had $21 million in the bank or something like that. And so all of it seemed great. The catch was he was buying it for his newlywed, and they were getting married in February. And so it was a 6-month contract. The client's got a $10,000 deposit. Unfortunately, and there's nothing you guys can do about this, but again, in my compensation and deterrent phase, if you've got $20 million, $10,000 is not that much money if you were to choose to walk away from it. It's a lot, but in that scale, it's not that much money to walk away from if you choose to cancel. Flip side, if you're carrying a $1.4 million house for 6 months, it's probably costing $5,000, $6,000, $7,000 a month, not $10,000 for 6 months. So if the deal were to fall through, you're probably not adequately compensated. So in a scenario like that, I would say $100,000 deposit is not unreasonable, and maybe even more, but 100, you know, again, 6 months, 100,000, that's probably a reasonable number, and it's probably a reasonable deterrent. So it covers both sides. So to spin out the story, and it's a sad story, they go on their, I guess it was a honeymoon cruise or something like that, and the gentleman dies. And so they hadn't closed yet, because they were going to close when they came back. And so then I get hired by the seller to sue the estate to force them to buy the property. Well, they weren't in a position to force this, they couldn't force the sale of the property, the purchase of the property. And the estate was not fighting over the 10,000. Here, take the 10,000. Like I said, it's not a big enough number to fight over. The very, very sad part of this story that there's nothing you guys could do about, no matter what you collect on a deposit, if you were paying attention and you've been around long enough. In August of 05, we were here. In February of 06, we were here. They ended up selling it for $800,000. So they got 10,000, they lost 600. So very sad, bad story, but yeah. So the, I don't recall. Let's see. Yeah, he just jumped. No. So that's the deposit lecture. The amount you put there should be enough to stop the buyer from just walking away. But sometimes buyers will walk away, whether it's willy-nilly or for sad but legitimate reason. The seller, sometimes there's nothing you can do. That's what the deposit is there for. It is to compensate the seller, to punish the buyer, so to speak, but it's not so much punitive. It's to compensate the seller if something bad happens and the buyer can't buy it. Well, make it a big enough number. So of course, if you're on the seller side, the bigger the number, the better. If you're on the buyer side, the lower the number, the better. But a fair minimum is for those reasons. Now, the line B, additional deposit, sometimes you might want to bifurcate the deposit. So especially if you're dealing with bigger numbers and somebody, doesn't want to throw, 10,000, you might want a $10,000 deposit. It's a $500,000 deal, and a $10,000 deposit is a reasonable number for the circumstances, 30, 45-day closing, but they don't want to tie up the 10,000 until after they've done their inspections, or that's usually what it would be, some reason for a delay. So you throw $1,000 deposit, initial deposit, to hold the deal. Look, we're legit, but after we get through the inspection, we'll give you the other $9,000, and then we'll have a $10,000 deposit. If you're going to do that, line 36, you'd put in a date. If you left it blank, so it says 10 days after effective date. So if you left that blank, then it would be 10 days. So you'll see in the contract, there's a lot of if left blank then, right? So this is the first time I skipped line 30, but this is the first time we're coming to it. If left blank, then 10. So you can put a 10 in. My opinion on blanks, sometimes I fill them in, sometimes I don't. For me, it's strategic because people think as an attorney, I'm pulling a fast one or something. So I always try to keep it as simple as possible. Say, look, we're using the standard contract. Yes, I'm an attorney, but I'm not doing anything I'm not trying to trick you. So I try to make it clear I'm just doing what the contract says. Again, if I am trying to trick you, you're not going to know it. That's the goal. So the 10 days, but if your goal was after inspections, I want to do 1,000 now and 9,000 after inspection, and you have a 15-day inspection period, then don't leave it with a blank of 10, because now you got to come up with a 10 and you're not done inspecting. So make it 16. Don't even make it 15, because now your inspection period and your deposit are due on the same day, and you don't want to, I'm going to get in default in just a second. So make it the next day. If you have a purpose for delaying the deposit, then make that purpose accountable by making the date appropriate. So now I'm going to scroll back up to line 30. As a title company, I prefer box 2, that it be made within blank days. Whether you do 1 day, 2 day, 3 day, I don't care. We sign the contract and then the party has to make the deposit. I don't like a company's offer. And again, I'm a title company. When you bring a contract to me signed by a buyer along with the deposit, I'm obligated to deposit that check into my escrow account. And now the seller doesn't accept the offer, right? Well, now the money's in my account, and you say, oh, they didn't accept the offer, give me my money back. I have to wait for the check to clear. So I'm waiting 7 to 10 days, and I'm sitting on your money and there's nothing I can do. I'm not giving you the money back until that check clears. So I don't want to take a check on a deal until it's a deal. That said, if it does accompany the offer, just be aware that that could happen. My recommendation and the default is to check box 2, and then the number of days is just dependent on your client, how quickly they'll get there.
On the day of business, 3 days, or midnight of the day?
Okay, so I'll get to time in a moment. So there was a question on the timing, and I'll get to that in just a moment. So now everybody, I don't know if you all have pens, if you're taking notes, you're just looking at your contract, but this is very important. On line 33, you need to write Waterview Title Services. Gotcha, yay. Okay, so the escrow agent. The escrow agent can be anybody, obviously. I'd like it to be Waterview Title. It's usually the title company that's going to handle the transaction. And in the MLS, you usually, if you're a listing agent, you usually put who the escrow agent's going to be. With all that said, to be clear, the escrow agent and the title agent that we'll get to in paragraph 9 are not defined as the same thing. You can have an escrow agent, Lack and Lack Chartered could be the escrow agent holding the money, and Waterview Title could be doing the title. ABC Title could be holding the money, but Waterview Title could end up being the closing agent. Waterview Title could be holding the money because you all did that, but the buyer has an attorney and they're willing to pay for the title and they want their attorney to do the title. Fine, I'll transfer it at closing. So the escrow agent and the title agent are not by definition the same thing. In practice, they usually end up being the same. But do understand legally, you can have an escrow agent and a title agent, and they can be two different entities. It's rare now. In the old days, brokerages, the Remaxes, Century 21s, a lot of brokerages would hold escrow. They're not doing that nearly as much anymore. Most people are just having the title company hold it, or maybe an attorney. But it really doesn't matter who holds escrow as long as they're reputable. So when I'm representing somebody and somebody else is holding, I want the other attorney to hold it, or I want my title company, even if you're handling the closing, I don't care who holds the escrow. As long as they're reputable, they're not going to run off with the money and they're going to transfer it to the closing agent, in time for closing. So again, I only care because when it gets sent to the bank's going to see Waterview Title. They're going to assume that Waterview Title is the closing agent, and it may or may not be, and there will be communication, obviously. But you do put the escrow agent name, address, phone number, email, fax number. They have made the lines a little bit longer for phone and email. Put as much as you have. That came out of, in the old contract several iterations ago, it just had escrow agent name and it didn't have contact information. And then when somebody wanted to verify the escrow, they didn't know where to go to deposit it for a buyer. Okay, Waterview Title, where are they? And again, I'm going back, not before Google, I don't think. Well, yeah, I do go back way before Google, but there would be times when you have trouble finding where they are. So the FAR bar said, let's put contact information for the escrow agent so we can reach them to confirm the deposit has been made and also where we're making it, et cetera. So that's A and B. Let me see, do I have any other notes on there? I'm going to get to, we talked about it, the additional deposit within 10 days of the effective date. And there was a question on time, but I'm going to come back to that in a moment. So moving along on how to fill out the contract here. We did financing. So line C is financing. You'll note all of the other line numbers have a $sign. The line 39 is blank because you can either put 80% or I'll use 100,000 as my purchase price, $80,000. So you can do it either way. Some programs now are calculating it for you, some are not. Again, doesn't matter to me. The way it's going to work is top line, line 27 is the total purchase price. Then you have your deposit, your additional deposit, financing, other, and the balance to close. So it's the top line minus, and then the bottom line is the cash to close. And again, I'll explain all of that more in a moment. So the financing part is how much the borrower is borrowing. When we get to the financing paragraph 8, I'll go into greater detail. But the way they've reworded paragraph 8 in this version of the contract, the only place the dollar amount appears, or the percentage, is on line 39. So it is critically important that you put, if there's financing, obviously cash deal, you don't need to do it. But if there's financing involved, you need to put the financing amount, either dollar or percentage, because paragraph 8 references paragraph 2C. And if you didn't put it, then you have a conflict, an internal conflict with the contract, and that opens the door for litigation. So our goal is to avoid court. To avoid court, fill it out properly. Filling out property is the amount of money they're borrowing. I've come back to some of the issues there, whether it's 80% or 90% or put a dollar amount. Again, that part doesn't matter to me. When we get to paragraph 8, I'll have some additional comments. Yes, ma'am.
Now, can the effective date be the executed date, the date of account, or be able to protect your deposit?
Okay, we'll get to effective date in just a moment.
Thank you.
So on the financing, put the dollar amount or percentage, but I prefer the dollar amount personally. A lot of people like to put the percentage because if they're negotiating the purchase price, it changes from 100,000 to 101 or to 99, then they have to change it. And if they leave it 80%, they don't have to change it. However, you still have to change the top line and the bottom line. You still got to do the math. So if you're doing the math anyway, I'm of the opinion, just put the dollar amount. But that's, again, the contract gives you that option. Now, line 40, other, my notes indicate it can be a thing of value. It can be seller. You can put seller financing there. PMM means purchase money mortgage. Now, if the seller is doing the sole financing, then you can put that under financing line 39. And when you get to paragraph 8, you'll note that it's seller financing. But if the borrower is borrowing 80% from Bank of America and the seller is lending him an additional 10%, then you would put that, or could put that on line 40, seller financing $10,000 or whatever. Again, it could be a gift of equity. I do a lot of transactions between parents and children. So the parents are selling the property to their children. The children are borrowing 80% financing. The parents are giving them the other 20%. So the kids aren't coming to the table with any money. The parents are waiving the equity. So it's a gift of equity. It's always a good idea to talk to the lender, to draft the contract in such a way that the lender will be happy. Legally, the answer is put gift of equity, $20,000, and you're good to go. It's going to come off the sellers, and it's going to go on to the, come off the buyers. They'll both be paying it, or one will get it, one will pay it. The other thing, again, it's unusual, but I said thing of value. I had a transaction where the buyer was also giving a boat to the seller. So we put boat $10,000. And, that's just, it's a credit to the buyer that the seller, buyer was giving the seller a boat and the seller was crediting the buyer $10,000. So again, that other can be other. It's a credit to the buyer of some form. And then we get to the balance to close. Is the bottom line. So line 27 minus the deposit, additional deposit, financing other, bottom line cash to close. Couple of significant notes. No matter what the contract says, in today's world, we require wire transfers. So don't ask, I won't say don't ask if you can do a cashier's check. If you call me and the circumstances are right, I might accept it, but assume that I won't, and assume every other title company in the area won't. We're all advised to only do wire transfers. So just tell your clients right up front, yes, you're going to have to wire the cash to close. We can take a check for the deposit provided the closing is far enough off that the check will have an opportunity to clear. So if it's a 30-day closing, I can take your personal check. I don't need a cashier check for the deposit. If the closing is in 3 days, I'm probably going to want you to wire the deposit because even cashier's checks are taking time to clear. That's the issue, is fraudulent checks. So I am sure your brokers have all warned you repeatedly about wire fraud and being careful and checking wiring instructions. Best practice, never send a wire without a phone call. You get the wiring instructions, that's great. You got them in print right there in front of you, that's great. Pick up the phone and call and say, I just want to verify the routing number and account number. That's all you need, routing and account number. And the routing number, if you got it wrong, you'll know it because it won't, but the account number is what matters. And the fraud out there is somebody intercepts an email, swaps out their account number for yours. The wire gets to some, and then it gets moved around real quickly before you know about it, and the money's gone. And whoever sent the wire is the one who's out the money. So be very cognizant of that, be wary of it. But it's a simple phone call. Verify wiring instructions, you're good to go. But explain to the buyer that they're going to have to do it so that it doesn't become a fight, before closing. Oh, I didn't even know I had to do that. Yes, you did. Now the balance of cash to close, you'll see on line 41, not including buyer's closing costs, prepaid, and proration. So another thing that happens is 100% financing. So you have a $100,000 purchase, a $1,000 deposit, 100% financing. So really the buyer should get $1,000 back. If you do the math, line 42 should be negative $1,000. You can do that. That's mathematically correct and no problem. I typically put a 0 there instead of the math negative. And my reasoning is I don't want to create this belief in the buyer that they're going to get money back at closing, because it's not including their closing costs, prepays, and escrows or prorations. And there's a very good chance they're still going to have to come to the table with money, even in 100% financing. There are closing costs that still come out of their pocket. So I usually put a 0 when the math is negative, but you're welcome to put the negative number as well. Just my opinion on that one. Okay, now, all right, I'm going to jump back to, let's see, am I going to jump there now? No, I'm going to go here first. All right, so I'm going to jump back to this screen in a moment, but while we're here, are there any questions? I do have one on Zoom concerning the deposit. Can the deposit be a gift from someone else? If so, does it have to be disclosed to the seller? Okay, so with regard to the deposit, as a title company, I don't care where it comes from. As a contractual, as an attorney, I don't care where it comes from. Once the buyer who signed the contract has made a deposit, it's not my problem. I'm holding the money. I'm either giving it back to the buyer if they're entitled to it, I'm giving it to the seller, or we're applying it at closing. But lenders may care about that. So a lender may want to source the borrower's funds. And so the answer, Anthony, is it's not relevant to the seller. As long as the seller gets the deposit. Again, I guess there could be a theoretical, if we have competing offers and we don't feel, if the buyer doesn't have enough money for a deposit, then maybe we're not confident that this deal will go and we'll take this deal over this deal. So there might be some relevance, but I don't believe there's any obligation to disclose to the seller where I get my money. If I'm borrowing it from my brother, that's none of your business as long as I have the money. But the lender is going to care. So it becomes relevant that your lender is going to want to know the source of funds. So any other questions in the room? Okay, then still not through page 1. Getting there. Time for acceptance and effective date. And then we'll see time, which is my next one. I knew it was coming. So actually, I'm just going to scroll down here because there's main information. There we go. Okay, so we're going to cover time in a moment. That's the next screen. But here on line 45 is our deadline for acceptance of offer. And I finally, this is literally it's the second seminar now that I'm doing where I finally wrote this down. For 15 years, I was going by memory and I finally wrote it down. So a quick legal conversation, a contract is a meeting of the minds between a buyer and seller. When a buyer signs a contract and presents it to the seller, they're making an offer. I hereby offer to buy this property from you. If you sign it, we have a binding contract. If you don't, we don't. Alternatively, a seller can make an offer to sell the property to the buyer. So the seller can sign it first. Whoever signs it first is making an offer. Whoever signs it second is accepting the offer of creating a contract. If the second signature never comes, we never have a contract. However, whoever signed it first is making an offer. Offers exist until, here, I got my notes. It gets accepted. Now we have a contract. Yay. It gets rejected. Nope, I'm not accepting your offer. Okay, no contract, we're done. A counter offer. So you know what? No, I'm not taking your offer, but I'll counter at 101,000. Now that counter offer has just become an offer, but the original offer is gone. The minute the counter offer was made, the original offer, which is what we're discussing here, is gone. Or it can be withdrawn. I can make an offer to you, and if you don't accept it, I can withdraw it before you accept it. Now, sometimes we end up with a legal fact question. Did you accept it before I withdrew it? Did I withdraw it before you accepted it? You know, that can be a fact question that could end up in court where a judge is a trier of fact. But if I withdraw it before you accept it, if I say, you know what, my author's withdrawn. No, wait, I'll take it. Too late, I withdrew it. You don't get to say, I'll take it. Or, I couldn't read my own handwriting. Withdraw before acceptance. Yeah. And then the last one, which is the point of this conversation, is expire. An offer can expire, and that's what line, now I took my glasses off and can't see, 45. Line 45 is the expiration date of an offer. So you can use this strategically, but please use it. Put a date in there. So if you want to say you have until tomorrow to accept the offer, you have till tonight to accept the offer, you have till tomorrow to accept the offer. We want to know right away, because if you don't take it, we're moving on. You put in a short date. If you're dealing with somebody, you know what? Take a week to think about it. No hurry. Just let us know. Put in a week. But make sure you put in a deadline. Make it so that the offer does eventually expire. Scenario. You don't put in a deadline. You go out Saturday night with your buyers. You find something you love. On Sunday, you put in an offer. You don't put in the expiration date, of course, in this conversation. And then you don't hear from the seller. You don't hear from the seller. You don't do anything else. You go out the next Saturday. You find another place. You put in an offer on another place on Sunday, and then they both get accepted. And you never canceled the other one. So you're now contractually bound to 2 contracts. Now, again, in today's world, you could probably get out of the one or the other, during an inspection period, but forgetting that, you are legally contractually bound to 2 contracts now, because you never withdrew this one and you never expired it. You just made another offer while it was still pending. So the punchline is, you don't want to have 2 offers pending. I mean, you can if one gets accepted and you withdraw the other, but be aware that you might be in that scenario. So don't let it happen by accident. Put in an expiration date, and then you can always extend it. So the other thing that comes up is, okay, I gave you till Sunday and you didn't sign the contract until Monday. So do we have a contract? This is one of those where I'm a little looser on the interpretation. You don't need, so when somebody accepts it on a Monday and you only gave them till Sunday, what they've really done is made a counter offer, or a new offer, if you will, because your offer expired on Sunday and they're now signing a contract that is effectively becoming an offer, because they're saying, yeah, we'll sell it to you on these terms. And now the buyer who had the expired offer has to accept it. Multiple ways to do it. Some people cross that out and put the Monday date and have everybody initial it. I'm fine with an email, a confirmatory email that says the parties hereby acknowledge that the effective date is, Monday, and we're, accepting it. Again, my picture for your head is, assume a fight. You're assuming you're standing in front of a judge. If you can hold up an email that says we confirm the effective date is Monday, then are they going to be able to say, well, the offer expired on Sunday, we didn't approve it? Well, you did approve it by your email. So as long as I can cover myself, then I don't ever want to go to court. But if I got my smoking gun piece of paper, then I'm not going to worry about it. So whether you do it on here, you do it via email, document somehow that we are live, then you're good to go. But definitely put that acceptance date in there so that you force the seller or buyer's hand. Again, it can go in either direction. As I said, a seller can offer, that would be a bigger issue I didn't even thought of until now after all these years. If the seller is the one who's made the offer and then the seller makes an offer to somebody else, then the seller could be bound, and the seller might not have an out clause. And now you got an issue of, you got a seller with 2 contracts, and that would be really bad. I haven't seen that happen, which is good, but it would be bad if it did. So now we get to time. Again, assuming we get an acceptance of an offer, the counter offers are hard coded to 2 days. So if I do make a counter offer, you have 2 days to accept it. So if my offer has expired, then by my conversation, we're deeming that a counter offer. So you just need the buyer to accept this delayed acceptance as a counter offer within 2 days. Again, an email or an initials or something to acknowledge that. But if it is a true counter offer, $101,000 or whatever, then you make them initial it, and they have 2 days to do that. Otherwise it expires. So that's the time for acceptance. Now the effective date of the contract, and I think this will go to your question, ma'am. The effective date of the contract is the last one of the buyer and seller has signed or initialed and delivered this offer or final counter offer. So basically, when all of the facts are approved, all of the terms are approved, so whoever made the last change the other side has accepted that last change. The date of that acceptance of the last change is the effective date, the date of the acceptance and delivery. So I sign it tonight, but I deliver it to you tomorrow. It's really tomorrow is the effective date because you didn't know I signed it until tomorrow. So again, this, I didn't have this conversation, but we're going over the FAR bar, the Florida Association of Realtors, Florida Bar collaboration on a contract. So we're using the FAR bar contract and we're using the as-is version. There's a non-as-is version as well. There are other contracts out there. The Florida Association of Realtors, FAR, has their own contract that's not a collaborative effort, and it has different terms in it. So again, as a lawyer, I will sometimes use different forms because they serve a purpose. I said to you, I don't want to, I'm not tricking you, I'm using the standard form, but I might have used a standard form that's different because it has different language in it that I'm aware of that you might not be. So one of the differences in the FAR contract I lost where I was going. I mean, I know it's time is one of the huge differences, and I'm going to get to that in a minute. But yeah, again, there it goes. It comes and goes. Yeah, I'm getting older. So I got it. It came back. Yay. So the effective date on the FAR contract, there's actually a place to put the effective date. At the end of the contract, if it's still there, I haven't looked at it in a little bit, but there used to be, and I think there is, a place to put the effective date so that the parties can in writing agree that the effective date is March 18th. And there it is. It's in writing. That's the effective date. And if the parties agree to an effective date, so be it. But FAR bar says the effective date is the date of delivery of the last change that's been accepted by the party. Usually, let's assume no negotiation. I make you an offer, you accept it. When the seller accepts the offer, the date of their signature or the date of the buyer's signature, that's the effective date. But there can be this issue of delivery. So the seller accepted it at night, but the buyer didn't know it about the next day. Effective date is critical. So any questions? So the issue on what I like to do on the effective date is, again, a confirmatory email. If there's a question, if it's signed and dated and there's no issues and everybody's delivered and here's our signed contract, congratulations, look forward to working with you, then there's no issues. But if there's going to be a question of I didn't get it till tomorrow and I want the effective date to be tomorrow because I want that extra day for inspections or whatever, then just send a confirmatory email saying this will confirm that we received the contract on April 5th and that and confirm that that is the effective date, and have the other party confirm it, and you're good to go. And if you do it right at the beginning, everybody's happy, everybody's expecting it to go through, they're going to agree to it. If you wait till the end and there's a fight over a day, which I'm going to get to in a moment, if there's a fight over a day, the seller says, I signed it on April 5th, and the buyer says, I didn't get it until April 6th. Well, did the realtor get it on April 5th? And I'll get to that in a moment. We end up with a fight over this day down the road when we're fighting. So resolve the fight now by confirming the effective date at the front end. And again, if it's obvious, you don't have to do it, but if there's any issue, or if you just want to get in the practice of doing it, it's a good practice. Now, time, which is something I'm running out of, is of the essence. So time is of the essence. You'll see that's bolded. I didn't bold that. That's how the contract reads. Time is of the essence. What that means is when the parties have negotiated a time frame, 3 days for the deposit, 10 days for the second deposit, 15 days for the inspection, 5 days for the provision of title, whatever time frame is stated in the contract, that is an essential provision of the contract. It has presumed to have been negotiated and accepted as an essential term. The spelling of my name is not an essential term. So if somebody had a typo in my name and I corrected it, that doesn't change the contract. I'm just fixing a typo. If you have the wrong zip code and I fix it, I'm not changing the terms. I don't need to be initialed by everybody. We're just fixing a typo. But if I change from 2 days to 3 days, that's an essential provision that would have to be initialed and accepted by the parties. So there's that piece of it. It does. Excuse me. So changes would have to be initialed if you're making a change. But my point here is time is of the essence. The failure to, let me see where the line is. Give me just a moment to find it on my handwritten notes. And cough. Other than the time for acceptance, where you're putting in a date to accept the offer, and the effective date, which is being calculated by the last person to sign and accept it, all time periods are computed on calendar days under the FAR bar contract. Excuse me. Now, if a time period were to end, and this is a minor revision to the new contract, well, one of the revisions is it's the time period of the location of the property. So this came out because we had foreign and Europeans doing business together. And so they're both over in Europe, and they're thinking the time is what it is in Europe, not the time it is one in Florida. And then there was a fight over time, and the one party said it's Florida time that matters. And they said, no, we're both here in Spain and it should be Spanish time. And no, it's Florida time that matters. So they built it into the contract to make it clear that it is the time in the where the property is located that is relevant. And I think, is there some parts in the Panhandle which might be different time zone? So that could be relevant is kind of the point. So then the other thing is if it ends on but thank you so much. If it ends on a Saturday, Sunday, national legal holiday, or here's the change, or a day on which the holiday is observed. So if we have a holiday on a Sunday and it's observed on Monday, then even though Monday is July 5th, that'll be considered the date of observance. Thank you. I appreciate, I'm getting waters and I thank you so much. And it is helpful, so thanks. So be aware of that. If a time period other than the deposits due, no, I'm sorry, not other than the deposits, other than the time for acceptance and the effective date. So time frames, if they end on a Saturday, Sunday, or national legal holiday or observance of one, it'll extend to the next business day. They did away with, and this comes back to Linda's question a while back, that might not have been asked out loud, but we've done away with 5 p.m. So contracts, a day ends at midnight or 11:59. So 5 p.m. is no longer a thing. That said, if you're talking about getting a deposit and I'm not in the office, you know, how are you going to get me the deposit if I'm not there? We don't want to have those fights. So assume for things that require a bank or a title company, assume 5 p.m. or business time because you need to do something with a third party. But for things like the inspection period, you got till midnight to cancel the deal. If you cancel it before midnight, you don't have till 5 p.m. You have until midnight to cancel the deal. So they, like I said, they did away with this 5 p.m. And if it used to say it would extend to the next business day, right, on line 437, shall extend to the next calendar day, which is not a Saturday, Sunday, or national holiday, blah, blah, blah. And it's not 5 p.m. of that day. It used to say we'll extend till 5 p.m. of the next day. It doesn't say that anymore. This version of a contract just says extends the next calendar day, meaning midnight. So again, just be aware of that. Now, so the FAR contract, and I did verify this, the FAR contract is still using business days and ending at 5 p.m. So while you're here in Brevard and you're using this form of contract, when you're preparing them yourself, or if you're receiving them from somebody else, if this is the form you got, you know what it says. I've told you that. If you're working with somebody like me who might decide to try to pull a fast one, and again, back in 03, 04, 05, when the market was crazy and people were trying, we want a closing in 30 days. And if you don't close in 30 days, we got 100 other people to sell it to. And I knew my client needed 40 days, but I was no way I was going to negotiate it. I slipped the FAR contract in and I sent them the FAR contract, and it's business days instead of calendar days. So I just bought 8 days. I bought 4 weekends of Saturday and Sunday. And it served my client perfectly. The seller got, at the end of 30 days, they're like, why aren't we closing? I'm like, well, we actually have, 8 more days to go. And it were, so be aware of, there will always, or reasonably always, be a definition of time in any contract. And the definition of time in the contract is what the parties have agreed to. This is what it is in FAR. But if you get a different version sent to you, look at it, be aware of what it says, because might be somebody like me pulling a fast one to protect my client, obviously, but so be it. Now, I do want to go back. Let me see, am I going back? Yeah. So the deposit, it is. Yeah, so the deposit is, again, to be made within 3 days of the effective date. So my notes here, first of all, notice calendar days and see time. But if you look on line 38, all deposits paid or agreed to be paid are collectively referred to as a deposit. And agreed to be paid, if you go to paragraph 15 on line 338, so everybody go to paragraph 15 on line 338, which is page 7 of the contract. A buyer's default, including the payment of the deposit within the time specified. So if you put 3 days to make the deposit and the buyer shows up on day 4, they're in default under the contract. And not only do they potentially lose their deposit, whether they've made it or not, the paid or agreed to be paid. So my example of the 1,000, 9,000 for a total $10,000 deposit. So the guy makes a $1,000 deposit, decides not to buy the place, never made the $9,000 deposit, is willing to walk away from the 1,000. Well, guess what? I can sue you for the whole 10. I'll take your 1 that's already in the escrow account, but I'm coming after you for the other 9. The fact that you didn't make the deposit doesn't mean you're not liable. Deposits paid or agreed to be paid are the deposit, and I can sue you for the 1 that you agreed to pay, even if you hadn't paid it yet. And it needs to be paid under the time provision within the time specified. So again, I've had people, I just had one recently, the buyer didn't make the initial deposit, 3-day deposit. There was some issue or question with an inspection matter. And she was, I'm not making the deposit until the inspection is done. And the answer is, if you don't make the deposit, you're in default. And not only are you in default, the seller can declare you in default on day 4 and sue you for the deposit. Now, in this case, the seller just canceled the deal. And I don't think it was a big issue. I think the buyer was okay with it being canceled. But if the buyer had wanted to fight, wait a minute, you can't cancel the deal. You know, I still want to buy it. Too late. You didn't make the deposit within the 3 days. So it is critically important that the buyers make the deposit. Otherwise, they're in default. And again, I try never to be the bad guy. And in my future world where I'm just going to be a title company and not doing litigation, hopefully I'll not have to be the bad guy. But I am often hired to be the bad guy to get people out of contracts and keep their deposit on either side. If I'm a seller, the seller hires me to keep a deposit. If I'm a buyer, please find a way that I'm not going to lose the deposit. The way I do either of those things is I read the heck out of this thing. I look for every loophole. I look for every line, and I try to say, hey, wait a minute. I'm on the seller side. The buyer didn't make the deposit until day 4. They were in default. We'll declare them in default and keep their deposit. It could be 25, 30, 40 days later. They're in default. I don't have a time frame to declare them in default. They were in default on day 4. I might have let it ride for a while. Now, again, if I'm standing in front of a judge, depending on what has transpired, might influence that. But the pure legal fact is on day 3, they didn't make the deposit. They're in default, and I'm entitled to declare them so and keep the deposit. And then on the buyer side, I would do other things to try to not have them lose the deposit. And I'll get to that in a moment as well. So be aware of time, be aware of the deposits. I think we covered, I went backwards to get that screen, but we got it. So now we're going to get through page 1. We're going to make it. And actually page 1 has now rolled over onto page 2 under the new version of contract. So I'm way ahead of the game. Closing date. Again, John Lack, I like to put on or before. I've had arguments with other people, don't put on or before, blah, blah, blah. You guys do what you want, and it's okay. The closing date is the contractual agreement that we're going to close on April 5th. Now, I like to put on or before, and my sole reason for doing it arises from many years ago. Lenders, if you put on or before April 5th, and you guys want to close on April 1st. If it says on or before, we close on April 1st. And if everybody's ready, then all is well in the world. If the contract just said on April 5th, lenders have in the past at least said, we need an addendum to close on April 1st. And I'm lazy, and going back years before the computers were as easy as they were and digital signatures were as easy as they were, we'd have to draft an addendum, get it signed by the parties, and then get it back, and all of that just to close on April 1st because some lender saw April 5th and said we had to amend the contract. So by putting on or before, I don't have to jump through those hoops. That's my sole reason for doing it. My explanation to the parties is that, but the other piece of it is we're putting on or before, but the on date is the last date. And if either party wants to hold to that date, they both can. Nobody's obligated to close before. It's not like on or before and the buyer says, seller, you have to close early, or seller says to buyer, you have to close early. No, it's the outside date. The on date is the date you have to close by. The or before is simply if the parties are in agreement and if the parties are ready, we won't need to amend the contract. So that's why I do it. Otherwise, put the on date. Now, part two, check the calendar, watch for weekends and holidays. Make sure days exist. So don't put November 31st. Don't put February 30th. I've seen it. They don't exist. I've often wondered, is February 30th really March 1st or is it really February 28th? I don't know. I mean, it's a legitimate legal question. Is it, if you put November 31st, did you really mean December 1st or November 30th? I mean, almost always, my last note, it does not have to be the last day of the month. Now, the reason people put the last day of the month is because of prorations and things of that nature. And it's really prepaid interest. So the way it works is when you close a loan, if you're borrowing money, your first mortgage payment is the first full month. So if you close on November 30th, your first mortgage payment will be due January 1st, and you'll pay interest for the November 30th. You pay prepaid interest from the day of closing to the end of the month. And if it is the end of the month, it's 1 day worth of prepaid interest. So it's a lower cash out of the buyer's pocket. So if you close on the 15th, you're paying prepaid interest from the 15th to the 30th, and then your mortgage payment's due on January 1st. So yes, it's a little more money out of the buyer's pocket at closing, but their mortgage payment is now due in 45 days instead of 30. Mathematically, it makes no difference, but historically, buyers have put the end of the month simply because of that. Now, what happens, again, title company, and I'm about to be a growing title company and be so busy because all of you guys, if you all put the 30th of the month, I'm going to be sitting around twiddling my thumbs for 28 days. And on to the day to 29th and 30th, I'm going to be doing 15 closings. And sadly, while I'll handle it and I'll make sure you guys are happy, there can be a domino effect. The closing at 9 a.m. gets delayed. So now 10 becomes 10:30. Now 11 becomes 1 and 1 becomes 3. And I'm here till midnight closing a deal on a Friday night. And I actually closed a deal at midnight on Christmas Eve many, many years ago. And that's not fun for anybody. So, and again, you can't get it funded until the next day anyway, right? Because, what are you going to, and the next day, 2 days later. So it doesn't have to be the end of the month. What I tell you is pick your favorite number. My favorite number is 22. Make all your contracts the 22nd. Of course, make sure it's not a Saturday or a Sunday either. So don't make closings on a Saturday. The bank's not going to fund it. We're not going to be able to close on a Saturday. Again, as a title company, will I try to be accommodating? I'll try, but close it on a Monday through Friday, non-holiday, and end of the month, you're all going to do it no matter what I say. So, and I still do it myself often, but it doesn't have to be the end of the month, and you'll find the closings go more smoothly if you're at a less busy time for your title company. But that's my notes on closing date. Wait, we have Karen. Oh, I already did that one. Okay, any questions? Not other questions, any questions on closing date? I'm going to keep us running through to at least get through to financing before our next break. So extension of closing date. So the CFPB, that's that thing that came out in 2014, but really effective in 2015. It was the proverbial pendulum swinging. So after we had the crises of 03, 04, 05 and lenders just lending money on, hey, I make $1 billion a day. Okay, here's some money. Then we had the crisis of 08 through 15 of, catching up on the mortgage foreclosure, short sales, all that fun stuff. CFPB, the Consumer Financial Protection Bureau, came out, and it's designed to protect borrowers. The point of this is lenders are required to disclose to borrowers what they're borrowing, how much they're borrowing, what they're paying, blah, blah, blah. It's all the disclosures the CFPB requires. When they built CFPB, there are legal disclosures that lenders are required to give to borrowers, and there's timeframes on those disclosures. So if for some reason, having nothing to do with the buyer or the seller, if the lender has failed to give a necessary disclosure in the time frame required, there's different time frames, but typically 3 days before closing for the CD is the big one you're probably all aware of or should be. And then there's a 7-day one and there's other disclosures, but the biggie is 3 days. If the buyer has to acknowledge receipt of the disclosure 3 days before closing. If they don't, the lender is federally prohibited from making the loan until those 3 days have elapsed. So if we're supposed to close on Friday, if they get it on Tuesday, we're good. If they get it on Wednesday, we're not closing until Monday. It's, the 3 days hasn't happened and we're not closing. So the contract says, I guess I need my glasses again. Extended line 59. So if it is, what did they change? They reworded it on me, so it threw me for a moment. Okay, so if paragraph 8B is checked, in other words, if you're financing, so if it's a cash deal, this doesn't apply because there's no lender. But if it's finance transaction, and you got loan approval and underwriting is complete. So they added, I forgot that they did this, but line 58, buyers were trying to take advantage of this clause in the last version of the contract and saying, we haven't gotten our disclosures, you shall extend. The way it reads, closing date shall be extended up to 7 days to give the necessary CFPB disclosures. So it's a shall, it's not a may. No matter how burdensome it might be to the seller is buying another place and they can't close on their purchase until their sale goes through, blah, blah, blah. Bummer. But if the lender, and here's where they added language, if we have a loan approval and it's been underwritten, so it's closing, well, this isn't we haven't gotten our disclosures. Well, you didn't get your closures because you haven't got approved for the loan. That's what, the game was. If they've been approved, we're ready to close, everything's done, but they didn't get their disclosures, then the closing date shall be extended. This is the part of the lecture where I'm educating you, so you're preparing your parties so that there's not a problem. There's nothing to fill in the contract here. I'm not telling you how to prepare the contract. I'm telling you the effect of the contract you're preparing. So be aware that keep your lenders on their game, make sure they're giving their disclosures, because if they don't, it might be the lender's fault, but they cannot close without that 3 days. And the seller can't say, forget it, never bind. The closing shall be extended. So again, be aware of that. Force majeure, those are what are typically or historically called acts of God, but it has been extended, and I cut and pasted paragraph G in there. It includes, if you go to line 442, all of those things, and they have added in the newest iteration of the contract, I'm not sure which ones are brand new, but insurrection, civil unrest, acts of terrorism, government shutdowns, epidemics, and pandemics. So those are the newer language. And the idea, the punchline to force majeure is, if something that is supposed to happen under the terms of the contract does not happen because of something completely outside the control of the buyer and or seller, whoever's supposed to perform. So I can't do something because we're in lockdown, or because there's a pandemic, or because there's a hurricane, or whatever. It's not my fault. I would be happy to do it if I could. I just can't. So if I can't do it, then the contract is automatically extended for up to 7 days after the event is no longer preventing me from doing it. So again, it's a variable kind of number. If the event lasts a week, then at the end of that week, I can now do what I need to do. I got 7 days to close. But so that it's up to 7 days. Now, if the event is such that it extends beyond 30 days, line 451, either party may terminate the contract by delivering written notice. So it is not automatically terminated, but if the seller says, I don't want to wait any longer, or the buyer says, I don't want to wait any longer, I need a place to live, or whatever, either party can terminate it if they're prevented from closing more than 30 days. So that's what force majeure is. Again, it's obligatory, it's mandatory, it's not negotiable. It's already been negotiated by signing it. So I shouldn't say it's not negotiable. You can put in a special clause that you delete force majeure, though I don't think I've seen that done. So that's that. Any questions on that? Okay, I did have a question, far bar. For initial deposit, it states within 3 days after effective date. So on day 4 of the effective date should be okay as it is within 3 days after effective date. No. So Reka, I hope I pronounced that correctly, but has asked, I'm going backwards on a Zoom question, but regarding the initial deposit, it says 3 days of the effective date, day 4. So you count days. So the effective date is day. So you do, I guess, day 4. The effective date is this, and then 1, 2, 3. So the effective date does, so I guess technically the way you're counting, the way you count days, I'm having to think about her question, but the way you count days is the day of is 0, and the next day is 1, then 2, then 3. So that's what that means. So maybe the answer is yes, Rake, I have to wrap my brain around it, but I'm going to keep moving right now. So, again, on the force majeure, one of the issues that comes up, the most common one is if we have a hurricane in the box and you can't get insurance, if they haven't already bound their insurance and a hurricane shows up, then they can't get insurance. They have till the hurricane leaves the box and then they can get their insurance and they can close. But as you see, there's an automatic extension. So it's not, the seller can't say too bad, you missed the deadline, the seller is stuck. And again, it can have very unfortunate circumstances of the seller, but it's just part of the world we live in. So occupancy and possession, I only know Florida, born and raised in Florida. I do not give legal advice or any kind of advice on any other states. I have some passing knowledge of how other states do things, and some of the things I hear about sound pretty cool, but we don't do them in Florida. One of the things we don't do in Florida, what they call dry closings, where everything closes, title company gets all of the money, all the documents, all of that. When the title company gets it, whenever that is, then we're closed. And then the seller moves out, and then we give keys and blah, blah, blah. So again, that's not how it works here in Florida. Possession is given, and you read line 65, deliver occupancy and possession free of tenants at closing. So it's at closing. When you show up to my office to do the closing and sign the documents, you're handing over the keys. It's, as a seller, you don't get to say, okay, great, we closed. I'm going to go back to the house and empty it now. Or I'm going to go back to the house. I just left a few things there. When you show up at closing, you're out, you're done, you're gone. It's not your house anymore. And you've delivered occupancy at closing. So be aware of that. Now, are these things negotiable? Everything's negotiable, but be aware that the contract provides that delivery of occupancy and possession is at closing. Now, if the property is, well, I'll do pre and post occupancy. Don't do it. Don't do pre-occupancy. Don't do post occupancy. Bad idea, never goes well, totally opposed to it. So with that, hopefully emphasized enough, there are going to be times when you're going to allow pre or post occupancy. Pre-occupancy is allowing a buyer to get into the home before they buy it. Really bad idea, because if they get in, right now they love the home, they're all excited. Once they get in, they find all the warts, they find out the little things that don't work. They decide it's not the home they thought it was, but they're already there. They got nowhere else to go. They haven't closed yet, but they're like, you know what, we're just going to squat right now. Go ahead and kick us out. By the time a seller goes through the legal process of kicking the buyer out, the buyer will have found something else, but they'll have lived, for 3 or 4 weeks or more in your house.
I'm good. How are you?
You legally get them out. So you don't want to do pre-occupancy. Post-occupancy, seller says, you know what, I'm closing on my home next week. Do you mind if we stay an extra week? Sounds great. You're being friendly. Yeah, we don't need it for, we can wait a week. No problem. We have a place to stay, blah, blah, blah. So the seller's deal falls through. So now the seller has nowhere to go. So they say, you know what, we're just going to squat. Go, and we'll find somewhere else to live. But until we do, we're happy in our old home. Thank you very much. And the seller doesn't leave. The buyer, of course, they're the owners. They can evict them or eject them. Eviction is when you have a lease and it's a written document and you evict them. And there's a relatively not easy procedure, but there's a procedure for eviction to kick somebody out of the home. Ejectment is when it is not written and they have some claim or argument of possession. then it's a different legal process and it takes a little bit longer. Same effect, but it's a slightly harder process. So A, don't do pre and post occupancy because they're bound to cause trouble. But B, if you do them, you need a pre or post occupancy agreement. And that's a lease. It might be called a post occupancy agreement or pre-occupancy agreement, but it is basically a short-term lease. And you put into that lease the right of eviction, security deposits, penalties. You put all the things that are in a lease so that if it goes badly, the landlord, the owner, whether it's the seller or the buyer, or whichever side you're on, has some legal authority plus some teeth, some penalty clauses. So if I have a buyer, by way of example, who wants pre-occupancy and it's an 80-20, they're $100,000 or borrowing $80,000, right? They come to the table with 20. I'm like, fine, put up your $20,000. Non-refundable. You want to move into the house, we want your 20,000. If for any reason you don't close, A, get out, and B, we're keeping your money. So now they're pretty substantially likely to close in that scenario. Now, again, the numbers can be skewed and you might want to only take 10 or something like that, but you want to make it so that the buyer doesn't cancel and or the seller is really well compensated, and vice versa for the seller. If we're closing with post occupancy, I'm not giving you your seller's proceeds until you move out. Now, again, if the seller's proceeds are $1,000, that might not be a great idea, but you want to make sure you have a written lease agreement. The title of the agreement might be post-occupancy agreement, but it's really a lease, and it's what gives you the authority to go to court and the teeth to do something with it. So A, don't do it. B, if you do it, contact me or some other attorney. You shouldn't be drafting leases. I've had realtors do it. Sometimes the brokers will have a lease, for you guys to use. I'm not telling you that you can't do that, but again, you want to be careful with the practice of law. You don't want to draft some post-occupancy agreement and find out that you're sued for unlicensed practice of law. So again, there are some exclusions for drafting leases. I just don't recommend you find yourself in that boat. Now, this is one of the loopholes I use for buyers. If you're buying a rental property, if there is a property that's being rented, now maybe the buyer is buying it for themselves, but there's currently a tenant in there. A seller is required, and this is line 75, shall provide copies of written leases delivered to buyer within 5 days of the effective date. So every once in a while, I might get a buyer who's trying to get out of a deal. And it says, if buyer determines, and this language will come up again in a moment, in buyer's sole discretion that the leases or terms of occupancy are not acceptable to buyer may terminate the contract. When something says in a buyer's sole discretion, that's what it means. They have the absolute right to decide. So they don't like the font that was used on the lease, and so they cancel the deal. How dare you use Times Roman instead of Arial? I'm not taking this contract. They can get out of it. Now, they only have a 5-day window to do it, 5 days from receipt. Well, let me rephrase that. The seller has 5 days from the effective date to deliver to the buyer, so failure to do so is arguably a default. But the way it reads is, where did it go here? Line 78, election of termination to seller within 5 days of receipt of the items. So again, I get a deal where a buyer comes to me trying to save their deposit, and they through inspections, they got the, everything. They have no excuse to get out, but it turns out there's a tenant in the property. And maybe the tenant's supposed to move out next month, but there's a tenant in the property. I say, did we get copies of the leases? No. I call up the seller, say, hey, I need a copy of the lease. They send me the lease. We say, ooh, you used 20-pound paper instead of 21-pound paper. Now, that wouldn't work because it's going to be emailed. But again, we'll go back to my font thing. I was trying to mix it up. We can get out of it within 5 days, and the contract gives me that out clause. So again, showing you how the evil bad attorney kills your deals. I'm not killing your deals. I'm using your contract against you if you weren't careful. So if you're a seller, make sure you deliver you abide by these timeframes. If you're the buyer, you may want to see it. You may want to keep it in your back pocket, depending on what it is. But that's the if it's occupied after closing. And now again, they added, if there's going to be post-closing occupancy, they've added this rider U, and they actually added rider T to line 70, 71 on the other one. Those are new to this version of contract, but it's same information, just a new highlight to you in your preparation of it. So I made it through that, see rider, and now any questions there? is it okay to do it on a separate lease agreement? Yes, you can. I mean, a post-occupancy agreement is a separate lease agreement, however you title the document. And if you title it, I mean, I've seen realtors actually attach the FAR lease and, just make it for 2 months or whatever. There's a lot of different ways you can do it. So one of them is a lease. Again, with all legal contracts, clarity is the key. You don't want there to be any vagueness and ambiguity. You don't want to end up in court saying, I thought this and you thought that. If that happens, if somebody can legitimately say, I thought this and you thought that, then you never had a meeting of the mind, and then I can get the contract thrown out as having never actually been a contract. I have a written agreement, but we misunderstood what the agreement said and we never had a meeting of the minds. It's a legal terminology, but I could use that legal terminology to actually void the contract, not void it, say that it never existed. We never had a meeting of the minds. So you don't want any ambiguity, and that's the key to doing this. So keep it out of the sale. Somebody was taught to keep it out of the sale. Well, again, I don't know. There might be fact patterns. This is on Zoom again regarding a separate lease agreement. I don't want to get into all the possible issues there. So we'll leave that for the moment. And we're almost through to financing. Excuse me. All right, here's another change in the contract. And in my mind, hallelujah, this is a long time coming. They added, if no box is checked, then buyer may not assign this contract. That's new language. If you strike that language the way it read before this version, under the law, all contracts are assignable unless specifically stated that they are not. So when people would leave these 3 boxes blank on the old form, it didn't say if left blank then. And so the default was it was assignable. And my note said, make sure you check box 3, may not assign. But now box 3 is the default. I still recommend checking it because I don't like the if default blank, but you can check it. Now, here's the issue. That's the default, and that's best for seller, may not assign. The seller has entered into the contract with the buyer. The seller has decided they like the buyer. They believe the buyer is going to be able to go through with the deal. And so it's not assignable. Sometimes you'll have if it were assignable, again, I'll take the negative front here. I sign up for the contract, I make it assignable, I decide I don't want to buy it, I have no legitimate excuse, but it's assignable. I can get a loan, I can get approved, everything's great, but I decide I want out. I assign it to my deadbeat brother. No offense, Jeff, you're not a deadbeat. I assign it to my deadbeat brother and he can't get a loan. And so under the terms of contract, I assigned it. He applied for a loan, got turned down for financing. We get our deposit back. So it's kind of a potential loophole to get out of a deal. Assignability can be dangerous. That said, a seller can always allow, the fact that it says it's not assignable, a seller could always allow it. You can, buyer says, hey, I need to assign this. Is that okay? The seller says, yes, we do an addendum allowing the assignment. A subsequent addendum would supersede this. So the saying it's not assignable doesn't prevent the seller from changing their mind. It just prevents the buyer from doing it without the seller's approval. Now, there will be times, and again, my note says, if somebody wants to may assign, then clarify if it's necessary. Is it for a family? I'm buying it now, but I want it to be in my wife's name, but she's out of town and can't sign the contract. So I'm going to sign the contract. I'm going to legally bind myself. But when Donna's available, I'm going to do an assignment, at closing for both of us to sign off on it. That's one example. Or I plan to form a corporation. It's going to be a rental property. I'm buying it in my name now because I haven't formed the LLC, but I'm going to form an LLC and I'm going to assign it to my own LLC. Commercial contracts allow for assignment automatically to related entities for that very reason. But the residential one doesn't have that built in. So if I know that's what I'm going to do, then I may check, may assign. And then it's a matter of explaining it to the seller. Hey, look, I'm not trying to get out of the deal. It's not that weird thing John was talking about. I'm going to be putting it in an LLC. So I need it to be assignable so I can do that. And then that's okay. I would usually check B or the second box instead of the first one. Again, the idea is let's hold the buyer liable. Even if they assign it, they're still liable if that due diligence is exercised and all of that. If you release them from all liability, then you've literally just assigned it. Your old buyer's gone, your new buyer steps in, which could be okay, but again, be aware of that. Okay, so that's the end of that one. Again, time is very much against me. Financing is really awful paragraph to get through. So why don't we take a 10-minute break? And then this is probably just based on me going to be our last break. So we'll make it a good 10 minutes, but do try to get back because I am behind again, as always, and we need to play some catch up. So see you in 10. And Zoom folks, I'm going to turn off the mic, but I'll turn it back on when I'm back. Hello, Zoom. We are about to start up again, so I'll give you all a second to get in your chair. I will apologize in advance for what is about to become an accelerated class because I told myself not to get behind and I'm behind. So and you guys haven't even asking too many questions. It's just me being me, but we'll do what we can. We are up to the financing section, and it is what I'm going to do. I'm going to make sure I get through this by doing my job of advising you how to complete the contract. There is, as you see, a ton of knowledge I like to impart so that you understand it all. One of my preliminary questions that I forgot to ask, but by show of hands, how many of you have read this contract from start to finish? Okay, so do it. It's long, it's boring. I'm going through it now, so that should help you or not help you. I'm not sure. You might fall asleep 2 or 3 times reading it, but get through it. There are things in here, bless you, that I am not going to be able to cover. There's a lot of standards that I'll fly through. I'll point out some highlights, but time is not going to permit me to go through them in detail. So you need to read it. I reread it I read it again last night. I reread it to remind myself. And even when I reread it for the 1000th time, I'm like, oh, I forgot that was in there, or there's lots of stuff in here that's built in. It's all important. It's all relevant. It's not relevant to every transaction, but when it is relevant to a transaction, you better believe it matters. So you really ought to read through it. With that said, I'm going to make sure you know how to fill in the blanks because that's my job. I'm going to try to impart as much information as I can. I will be talking fast and I apologize for that, but it's the only way to get through. So financing, I like to do C and D before I do A and B just because it's easier. So jumping down to C and D, which are lines 132 and 133. The assumption of an existing mortgage, I have been saying for a lot of years now that this is going to start being valuable, and it hasn't yet, but I think I'm finally going to be proven true many years later. So we have not had assumptions of mortgage since the 90s. I don't remember doing an assumption for a very long time. So I don't cover it as a rule. If your buyer is buying a property and the seller has an assumable mortgage, then there's a rider for the terms on it. And the buyer can, in essence, apply to the seller's lender to assume the pre-existing mortgage. It has not been used in 25 years to my knowledge. And I won't say never, but it's so rare. However, I have closed a lot of loans in the last 10 years with interest rates in the 2s, 3s, even 4%. If rates get up to 6 or 7% again, which I don't know when or if they will, or even 5%, which is still an amazing rate. But if somebody had a 3% loan and it was a VA loan or FHA loan that was assumable, that's valuable to a potential buyer if they can qualify. Now, again, there's hoops, there's they have to still qualify for the loan, but it might be a very valuable thing for a seller to say, I got a 3% loan that's assumable. So that may come up in the future. Again, I've been saying that for a dozen years now. It hasn't happened yet, but now that rates are starting to creep up a little, maybe I'll be proven right. If it happens, check box C and so be it. Paragraph D is seller financing. My notes there are, it says C rider, C for terms. You need to disclose terms of a purchase money. Purchase money mortgage is when the seller is lending the money, whether it's all of it or a portion of it, but the seller is what they call holding paper. So I'm selling the property to you for $100,000, but I'm lending you 80,000. So you only have to give me 20 and I'm the bank. You're going to pay me just like a bank. So what I say in that scenario, the seller is becoming a lender. How many lenders have attorneys and how many attorneys do the lenders have, right? Bank of America's got lenders, attorneys preparing all of their documents, and then the title companies may close them. But a seller that becomes a lender should have an attorney drafting documents on their behalf. Title companies, there is an exclusion the way you guys can prepare a contract. A title company can prepare a mortgage because they're insuring it, and you're allowed to prepare a deed and a mortgage because you're insuring it. But unless the title company has an attorney on staff or is an attorney, then they cannot legally prepare a note. I'm not saying they don't do it, and I'm not going to rat anybody out, but preparation of a note is practice of law, and a title company should not be preparing notes and mortgages for sellers. So the seller's becoming a lender. They should have an attorney. The terms need to be clear and they need to protect the lender, not to cheat the borrower, but the borrower is borrowing money just like they would against Bank of America, and they should be treated as a borrower accordingly. Maybe a little friendlier or easier, but it's still the same legal protections. So those are C and D. If you're doing them, attach the appropriate riders and fill them out. Jumping back to A, that's my obvious favorite, cash transaction with no financing contingency. Those are great, cash deals. We don't have to worry about banks or any of that. Now, they did what I consider a bad, unusual change on this version of the contract. And I remember in 2010 when they made it good, they went from, there was a 4, the 7, the 10, and 4 and 7 I thought were bad, 10 was good. Now we're up to 21 and it's bad again. This is a cash transaction with no financing contingency. The relevant language is no financing contingency. What they put in 10 and they took out here, and I don't understand why, is if the buyer gets a loan, it's still not contingent on financing. So buyers are allowed to borrow the money. The fact that they check box A doesn't mean that the buyer is not allowed to borrow the money. And it doesn't mean that the seller can prevent appraisals or prevent surveys or prevent inspections because it's a cash deal and there's, your lender wants it, but I don't have to give it to you because it's not contingent on financing. They're allowed to get a loan and the sellers still need to cooperate with the process to some degree. But what it means is no financing contingency. So if for any reason the buyer doesn't show up to the table with the money, I don't care where it came from, but if they don't show up with the money, then unless there's another clause, they lose their deposit. They're in default if they don't close and they don't have a excuse that I couldn't borrow the money because they said that they had the cash to do it. So that's what cash transaction with no financing contingency means. It really means no financing contingency. How they get the money is none of your business. What it means is they got to show up with the money or they're in default. Now we get to the normal and the longer paragraph. B, most people who buy a house do need to borrow the money. We have a lot of cash buyers now, which is awesome, but most people still need to borrow money. So as much as I want to buy your house, as much as I love your house, I'm willing to pay the $100,000 you're asking, but I need to borrow 80. If the bank will not lend me the 80,000 as much as I want it, I can't buy it. So it's contingent on that. Now, the obligation's on me. I'm going to go with the defaults. Of course, you can change them. So it's contingent upon within 30 days of the effective date. That's the loan approval period. Now they've changed the contract, so I'll explain it. A, the buyer has to get an approval of, so let me go back for a second as to filling in the contract. Very important. You must check one of the 4 boxes, A, B, C, or D. It's either a cash deal or they're borrowing money or they're assuming a loan or they're getting seller financing. There's no 4th option. So it's very important that you check the box. I have seen a lot of contracts where paragraph B is not checked. It creates an issue. Is there a financing contingency or not, right? They filled in the terms, so logic just says it was a typo and we missed it. I don't want to go to court telling the judge, well, obviously we just missed it, because the judge will be able to say, well, you missed it, so it's not contingent on financing. So check a box. Now, assuming we checked box B, 30 days is a reasonable period for loan approval. For a while, the 2016 version, I think it was, or 15, when CFPB came out, they redid the contract and made the default 45 days because nobody understood CFPB and nobody understood disclosures, and closings were taking longer to put together because nobody understood the new rules. So they made it 45 days. Well, everybody's back on board. We all know how it works now. We all know how to close loans. So we're back to 30 days. If you got a loan officer, I'll get your deal closed in 20 days. Don't worry about it. You can put a shorter time frame in there. But, and again, sellers would like that, but as a buyer, be realistic. Again, you have to get it within 30 days. If you get it earlier, that's cool. But if you don't get it within 30 days, then you have to either cancel the contract or, risk it or get an extension. There's a variety of options, but you have to do something. So 30 is a good number. If you want to go less because somebody assures you can get it done, that's fine, but just be aware of it. So we'll go with the 30 for now. A loan approval of, is it conventional financing, FHA, VA, or other? I always have trouble thinking of what other might be. Did I scribble any notes here? I still don't have notes. I'm gonna have to come up with another. But if there's some other kind of financing, some money coming in, private, I guess private is what I usually say. Or if it's private lender financing, so you can put private there. But FHA and VA do require a rider. There is an FHA rider. So if you're going to do that one, you want to make sure you include the FHA or VA rider because it has additional language. If you're doing conventional financing, so be it. But it is important to check one again because the borrower has to apply for a loan. I'm going to get to this in a moment, but what we fill in here matters. Now they're applying for a loan for a fixed, adjustable, or fixed or adjustable. Now, I've rarely known anybody who wanted an adjustable exclusively, and if they got approved for a fixed, they wouldn't take it. But some people might be willing to do fixed or adjustable. So again, most people are applying for a fixed rate loan, and again, you check the box, but you check one of those three boxes. Now, they did add this a few years back, and again, I was very happy because we as attorneys used to write, oh, wait, I skipped a line. No, I'm right. That's where I am. At an initial rate, interest rate not to exceed blank %. So what this says is the borrower is applying for a loan, but the borrower needs to do some soul searching, financial soul searching, and say, how much can I really afford? If I get a 4% loan, can I afford to pay it back? You know, I don't want to end up in foreclosure in 6 months. What about if I get a 5% loan? So for the borrower, the lower number you put there, the better, because the borrower can accept any loan they get. So if the borrower puts 4% and they get approved for 4.5%, they have the right to cancel saying, I didn't get the loan I applied for, or you know what, I'm happy I got a loan, I'll take it at 4.5%. The seller, on the other hand, wants the higher number in there. Hey, put 5%. If you get 4%, more power to you. But as long as you get approved for 5%, you know, you still have to close. If they come in at 6%, then you can get out of the deal. So the new blank they added, because we used to add as attorneys, we used to put the word prevailing is what I used to put in there. And now they've added then the prevailing rate based on the buyer's credit worthiness. Important to note, based on the buyer's credit worthiness. So somebody might lend me a loan at 18%. So if I get approved at 8% and this just has prevailing rates, well, if I got approved for a loan, I got to take it because that's the prevailing rate for my bad credit, but somebody made me the loan. Again, I'm exaggerating. That's probably not going to happen that way, but that is what could happen. So again, if you're a buyer, you want to put in the lowest reasonable number because it's an out clause. If you don't get approved, you can get out. For a seller, you want the highest reasonable number because it's an out clause for the buyer and you don't want them to be able to get out. Or you can leave it with the prevailing rates and let the chips fall where they may. If you get approved, you're happy. For a term of, again, I'm of the opinion that 30 years is a good way to go. A lot of people want a 15-year loan. Again, it doesn't prevent you from trying to get a 15-year loan. But if you actually want a 15-year loan, you should put it in there because it's harder to obtain because your rates are higher. So if you know I want a 15-year loan, then put it in, but otherwise the default of 30 is normal. So I'm going to come back to the appraisal for a minute because I want to keep my mind moving forward on the application. So jumping to line 97, the next blank, buyer shall make application for financing within blank 5 days after the effective date, if left blank. If you know your borrower's going out of town, you're signing the contract and they're going on a cruise and they're not going to be back till next week, you put 5 days in there, they don't apply in 5 days. I'm going to say, I can't tell you how many times I probably could if I thought about it, but when a seller comes to me and is trying to keep a deposit and the buyer says, I either got turned down for financing or I'm canceling for this or whatever, other than the inspection, remember that one's too easy, but buyer saying I got turned down for financing. I say, well, let me look, you know, I'll do my research on behalf of the seller. Let me look. Oh, look, you applied for the loan on day 7. You were in default by not applying on day 5. That clause gets stricken. You no longer have a financing contingency because you were indeed, you didn't apply timely. The legal effect is to strike the contingency. So, or I can declare you in default either way. I'm keeping your deposit. So the buyer, absolute time is of the essence. If you put 5 days to make application, you better make application within 5 days. If you know you're not going to do it, put a 7, put a 10. You might have to explain to the seller why you're waiting 10 days to make, you know, I thought you wanted this house, apply tomorrow. Well, I'm going on a cruise, you know, at 7 a.m. I'll apply as soon as I get back. All right, again, if you explain it, that's fine. Hopefully the seller will accept it. But if you don't put it in, you're in default if you haven't made the application. And anything that happens after that is irrelevant. You're going to lose your deposit if I'm on the other side, at least I think. So very important. Now, the other thing related to this financing contingency, you need to make application for the loan we just described in that first paragraph. Conventional financing for 30 years at 4%. Well, you don't apply at 4%, but you apply for the loan. So if I have a borrower who, okay, that's the part, I knew it was something in my head. Line 92, this is where they say in the loan amount, see paragraph 2C, right? Now, remember I told you I'd refer to it later? Seems like hours ago. But that's what you put on line 2C way back here. And 2C is the financing, the dollar amount or percentage. If I have a borrower who wants to borrow 90%, but is willing to do it at 80%, or flip the tables, they want to do 80%, but they're willing, they'd like to do 90, but willing to do 80 or vice versa. What you have, the borrower has to apply for the loan. That's paragraph 2C, whether it's 80 or 90%. If they apply, if they put 80% on the contract, but they applied for a 90% loan and got turned down, and they send the denial letter to me and I'm the seller side, I say, oh, you didn't get turned down for an 80% loan, you got turned down for a 90% loan, not relevant to me. Oh, you never applied for an 80% loan, we're keeping your deposit. So what they need to do is apply for the 80% loan and tell their loan officer, hey, if I can get 90%, do that also, but run me through at 80, and then if I can get 90, great. Or vice versa, put 90 on the contract, and if I get approved for 80, maybe I'll still buy the place, but if I decide I don't want to and I don't get approved for 90, then I don't have to. So again, understand you need to apply for the loan that you put there, otherwise you're in default. Anything beyond what you put there, that's up to you. You can do anything you want. But if you're trying to get the deposit back because of a failure of a contingency, you need to abide by the exact terms of the contingency. So any questions on that? Because I feel like I bounced around a little bit. Yes, go ahead.
So in this case, the range of the interest, I thought that its percentage was in the correct.
Yeah, that's correct.
Oh, okay. And what is the of the 8% information?
That's on paragraph 2C for the loan amount on page 1. If you look up on the screen, on page 2C is the financing, either a dollar or percentage. I, again, typically put the dollar amount, but I was using the terminology of 80% or 90%.
Okay, so where it is better to 90%?
No, there's no better. No, there's no such thing as better. They're fat. Why I've been doing this for 35 years and why I plan to do it for another 30, and the reason my dad did it for 60, it's the same stuff over and over again, right? It's not. Everybody's different. Every transaction's different. Every property is different. It's really fun because there's different personalities, some good, some bad, but it's a fun business to be in because even though what I'm doing every day is almost the exact same thing every day, it's different every time. So there is no better. It's what is appropriate to your client. Does your client want 90% or does your client want 80%, or are they willing to do either? And which way protects your client better? So
another thing is for the loan approval, conventional FHA or VA. So I heard that if FHA or VA ever pays,
right, I'll table that for a minute. There was another question over here, I think. Yeah.
Mine is just a deep question.
Okay.
So I have a seller who's willing to do the financing.
Right.
I suggested to him that he needs an attorney to write the note. First thing he's going to say to me is, what's the cost? Is there a range that I could give him an understanding?
Let's talk afterwards. I don't like to quote things as far as that goes, and different attorneys might have different opinions on that. So we can talk afterwards on that. And with regard to the FHA VA, yes, there is a rider, and I won't have time to cover it, so I'll mention it now. You need to look at the FHA and VA rider if that's appropriate. And there's an FHA portion and a VA portion on the same rider. And there are fees and expenses that a seller would have to pay when a buyer gets FHA financing or VA financing. So there are cost relevances to it. preparing the contract, it's not a big deal, but just explaining to the seller their net sheet, that's where you need to understand it. And again, don't have time. I can talk to you afterwards, but I don't have time to explain the financial piece of that puzzle. From a legal perspective, if you read it, it's somewhat clear as to what needs to be paid. And there's only one blank to be filled in, and that's for inspection stuff. So we'll get to that. Okay, so now we come back to the new thing that maybe you guys have heard about and all the hullabaloo about the appraisal stuff. So in the old form, there was an appraisal, what I call a pseudo appraisal contingency. I'll explain what I mean by pseudo appraisal contingency in a moment. I reread this like 3 times last night to wrap it in my brain, and it actually clicked a little bit. So that's good news. They just moved the appraisal contingency is really what they did. And they moved it into part of the loan approval. So now the buyer has to obtain loan approval, right? In a 30-day period, they have to obtain loan approval. Built into the definition of the word loan approval is A, that they've been approved for credit worthiness to obtain the loan they've applied for, and B, that the lender has received an appraisal or alternative valuation satisfactory to the lender, if required, sufficient to meet the terms required by the lender to provide financing. So the point of it is the lender is going to make the loan based on both the credit worthiness of the buyer and the value of the property. And if you're borrowing $80,000 on a $100,000 property and it appraises at $90,000, the lender's probably not going to lend 80, they'll probably only lend 72. And so your appraisal, your loan, the borrower will not get approved for an $80,000 loan because not because of their credit worthiness, but because of the value of the property. And so they won't get approved, and the buyer will have the right to cancel or maybe come up with the extra 8,000. But again, legally or contractually, if they don't get approved for the 80,000 because of the valuation, then they don't get approved. Now, the reason I use the word pseudo appraisal contingency is give you a different example. $100,000 purchase price, $50,000 loan. It only appraises at $90,000. If you read the clause, which is sufficient to meet the terms required for lender to provide financing. Well, the lender might say, you know what? We'll still lend you $50,000 on a $90,000 property because that's still whatever the loan to value is. My math is too slow, but that's still a sufficiently low loan to value that will lend you $50,000 on a $90,000 property. So now they've gotten approved for the loan, even though it appraised at $90,000. The buyer is going to not pay any more. They're paying what they agreed to pay. They're borrowing 50 and paying 50, but the borrower is going to be like, wait, I'm paying 50,000 when I should only be paying 40,000. Well, no, you agreed to pay $100,000 for the property, and that's what you're going to pay. So it's a pseudo contingency. More often than not, your loan to value will be such that the lender won't make the loan if it doesn't appraise. But there are scenarios where the lender will say, you know what, we'll give you a 90% financing instead of 80%. We're going to approve this loan anyway. And bada bing, you got approved for your $80,000 loan on a $90,000 purchase. And again, it's not costing the buyer money. It's not like they have to come to the table with more money. It's they're overpaying for the property, which in this market is a common occurrence, I suspect. But so that's what the appraisal contingency is. Now, moving forward, again, nothing to fill in, but information you gotta have with regard to the financing, because I get calls on this regularly. So we've already gone over now what the loan approval is, right? You have to apply for the loan in a timely manner or you're in default, and you have to get approved for the loan you apply for, or your contingency goes away. How does it go away? First of all, if the buyer does not use good faith and due diligent effort to obtain the loan, then the buyer is considered in default. So what that means is you can't sabotage your own loan. You can't not apply. Well, if you don't apply, that's obvious, but you can't not provide tax returns. You can't not provide W-2s. If you don't when the lender asks you for stuff, you got to give it to them. If you don't give it to them, they're going to deny you for the loan. You're going to get a denial letter. But if you read the denial letter, it says did not provide tax returns. If that's sent to me as the seller's attorney, I'm going to say you didn't use diligent good faith effort and I'm keeping your deposit. So even though you got turned down for the loan, I'm keeping your deposit because you were in default for not using diligent effort. So you can't sabotage your own loan. And then it defines that a little bit. Buyer shall, this is always, again, this is mildly entertaining. Buyer shall keep seller informed. They added upon written request because the old form didn't say that. So shall keep seller informed. All of a sudden there's this obligation to constantly inform people. So now the seller and or broker have to request in writing, hey, let us know what's going on. That's just a mild protective thing. But the funny part is line 108, buyer authorizes buyer's mortgage broker, lender, closing agent to disclose such status and progress and release preliminary and final disclosure, blah, blah, blah. So theoretically, you could call the lender and ask them what's going on. And you could send them this contract and say, the buyer authorized you to talk to me. Practically no lender is going to talk to you anyway. So even though you got the written authorization, even though it's there in the contract, it doesn't really work that way. That's why I say it's funny, but it is there. And you could argue with a lender, hey, here's the written authorization for you to tell me what's going on. So here's where it gets tricky, and it's a read, and you're going to have to read it a couple times and wrap your brain around it. I'm going to do my best to make this as clear as I can and point out the highlights. If within the loan approval, so we're going to call it 30 days, if the buyer obtains loan approval, yay, we got our loan approval, woohoo, you shall is a mandatory, not may, it's shall. Buyer shall notify seller of same loan approval in writing before the expiration of the approval period. So you got it in 30 days, you got to tell them in 30 days, not in 31 days. In 30 days, I got the loan approval and I'm going to tell you. Now I can wait 30 days to tell you. I could get a loan approval on day 2 and not tell you I got it till day 30, but I got to tell you I got it within the loan approval period. If I don't get the loan approval, I can still say, you know what? I know I'm going to get it. There's been a delay. My lender's slow, but I have faith and confidence I'm going to get it. So in that same letter, I can say, during the loan approval period, I have convinced that I will get the loan. How did they word it? Satisfied of my ability to obtain a loan approval. So I put in writing within 30 days that I'm satisfied that I will obtain loan approval. You got to send that letter. I either got loan approval or I'm satisfied I'm going to get it. That keeps options alive. I'll come back to the options that keeps lives in a moment. But the bottom line is you're effectively waiving the contingency because you got the loan approval. So you don't get to go back and say, wait a minute, I want my money back, I didn't close. You can't say that because of the loan, because you've effectively waived it because you got the loan approval, which already includes the appraisal, right? That's part of it. That's part of the little twist on this. So that's paragraph 3. Paragraph 4 is the alternative. I'm not able to get the loan approval. I didn't get it, or there's terms in the loan approval that I can't meet. The lender's requiring, I wish I had a sample of a term, but cannot timely meet the terms of a loan approval. So there's something in there that the lender's requiring that you can't do. So whatever it is, the buyer can, after diligent effort, again, you can't cheat, the buyer can terminate the contract with a written notice prior to the expiration of the loan approval period. Again, remember that 30 days. So anytime. So on day 10, I realize I'm not getting the loan, I can terminate the contract and say I didn't get it. The seller can't, there's one of the changes, or at least stated now, the seller can't make the buyer apply 10 more times. I tried to get a loan, I used good faith effort, I didn't get a loan, I went to my lender, they said no, I don't have to apply to your lender, I don't have to apply to 15 other people, long as I made a legitimate effort, I didn't get it, I'm canceling the contract. So again, I'm the seller's attorney, I'm going to make sure they really did what they were supposed to, but if they did, then they'll get their deposit back. But if they don't, so there's a notice in either scenario. Got my loan approval, yay, or I'm willing to assume I'll get it. Didn't get my approval, terminating the contract. Both of those things, one of those things has to happen within 30 days. So now typical people, we screw up. We got our loan approval. We're very excited. We just didn't tell the seller about it. bad mistake. And under the new version of this contract, really bad mistake. So if buyer fails to timely deliver the written notice, regardless of whether you got the loan approval or not, if you don't deliver the notice prior, within the 30 days, then buyer will proceed as if box A was checked. Cash deal, no contingency for financing. So it doesn't automatically terminate the contract. We're good to go. You didn't give me my notice. We're going to closing. However, if for some reason you don't close because of the lender or any other reason really, but let's assume the lender ended up not closing, you've waived that contingency. You're still losing your deposit. Even if it might have appeared to be a legitimate reason, you waived it. You're on cash, no contingency because you didn't give the notice. If you don't close, you'll lose your deposit. So that's lines 121 and 122. Provided, and here's the killer, and I've had several phone calls from really upset realtors, and it's a really awful scenario because of this crazy market we're in. Buyer gets loan approval, but doesn't send the notice. Remember, you must send the notice, either terminating or got loan approval. Didn't send the notice. The seller has a 3-day window to terminate the contract. So day 31 rolls around, seller's got 8 other people willing to pay more money for the property, but he's been stuck with you for 30 days waiting for you to get loan approval. You never told him about, you got the loan approval. You're feeling good about yourself. Yay, we're buying our new house. You didn't tell the seller. Day 31 comes, you get a notice of termination. You're like, what do you mean? Wait, I got my loan approval. Too late. Time is of the essence. Seller's got 3 days to cancel, and they canceled. And there's nothing you can do about it. You didn't give them the notice. They timely canceled, you lose. And again, that's what the contract says. And I've got a few really, really unhappy buyer's agents because it's not the buyer's agent's fault. You guys are not attorneys. It's not your job to do the job of the seller, the buyer. But a lot of times they're counting on you, or you're feeling really bad about it. So that's why you're here, to learn these things so it won't happen to you. If you get loan approval, send the notice. If you don't get loan approval, terminate the contract or send the notice that you're okay getting it. If you don't do that, you got this 3-day cringe period. Now, the good news is if they don't cancel within the 3 days, then we're just proceeding to closing again. But if you didn't give the notice, you waive the contingency, and so be it. But at least you get to continue to closing. But there's that 3-day period where you're at serious risk with no defense. Now, if the buyer does deliver the notice, obviously, if you terminate the contract, you get your deposit back. If you send the notice that I got the loan approval or I expect to get it and I'm waiving it, then where are we? We're in paragraph 5 now, or 6 rather. Then if the buyer, after doing all that, if you don't close, you lose your deposit because you have no reason not to close, and you didn't close, you lose your deposit. But this is only available if you timely deliver the notice. So the unless only applies when you give the notice. Unless the seller is in default or unable to satisfy other conditions of the contract, or property related conditions to the loan, excluding appraisal, have not been met unless conditions are waived. So it's a really hard sentence. But the punchline is you might get a loan approval that says we need a new roof, or you might get a loan approval that says we need, something fixed on the property. So because this is where it gets confusing to me, and I reread it a few times, because this is an as-is contract, it says unless it's been waived, unless such conditions are waived by other provisions of the contract, and they are. They're waived. I don't know if I wrote down the paragraph they're waived by. I didn't, but it comes, it's paragraph 12. I know that. Yeah. So line 274, buyer shall be responsible for any and all repairs and improvements required by buyer's lender. So the seller doesn't have to make those repairs, and if it doesn't close because of those repairs, then the buyer can get their deposit back. But again, it gets a little tricky with the property related conditions. The takeaway from this is please, please, please apply on time, apply for the loan you're applying for, use diligent effort and good faith. If you get approved, send a notice that you got approved. Don't hold that in your back pocket because it doesn't do you any good. If you get turned down, send the notice that you got turned down and terminate the contract, or maybe renegotiate or do whatever you need to do. if you do nothing or you don't timely apply, the deposit is what's at risk. So again, if you on the buyer side, you manage to get a $500 deposit, maybe you don't care. But if it's a $50,000 deposit, you probably care a lot. So follow those rules. So that's mildly complicated, and I only have 29 minutes left to do the rest of the contract. Are there any significant questions that I'd like to answer? Yes.
How does pre-approvals?
Okay, so pre-approvals are meaningless pieces of paper that make you feel good. That's really all they are. They're a lender saying that they've run the buyer's credit, and the buyer told them they make $1,000 a day. The lender didn't verify that. So I said, okay, if you make $1,000 a day and your credit looks decent, we'll make you the loan. That's what a pre-approval is. It's not binding, it's not controlling, it's not a loan approval, it's not even an application. So you need to make application, you need the contract. Because so people will do a pre-application and get everything ready. That's great, but you still have to send the contract to the lender because that's the the contract is what the lender is going to make the loan on. So you can't get a pre-application. Even the 5 days to make application might mean 5 days to send the contract to the lender if you've already done everything else. But application and pre-approval is just, again, a feel-good thing. Okay, so now, the next couple pages are tough, but I'm going to go fast. Again, it's going to be explanatory. There's not a lot of filling in, but the contract hard codes, what costs are paid by the seller, what costs are paid by the buyer. Primarily seller expenses are documentary stamp taxes and typically real estate commissions. In Brevard County, I'm going to cover this, but owner's policy charges, which we'll cover in a moment, and title search and municipal lien searches are typically seller expenses in Brevard County. Condo estoppel fees and any other documents plus seller attorney fees. So those are your primary expenses. FIRPTA, I'll mention briefly. If you're a foreign investor in Real Property Tax Act, that's what FIRPTA stands for. If you're a non-US citizen selling property in the United States, then you either have to have a withholding, FIRPTA withholding, or there's some other exemptions. And in the standards, I'll mention it again, but be aware that a seller may have to have withholding if it's a foreign investor. I'll try to cover more on that later if time permits. Costs to the buyer are the mortgage and lender fees, recording of the deed and the note and mortgage and any lender expenses. A survey would be their expense. Now, one of the things that in loan expenses, and insurance, the one that often gets caught up a little bit is HOA or condo estoppel fees are when the association is telling you how much, if any money is owed, what it's paid through, all of that. That's the seller's obligation. And these lenders, these companies are charging $250, $350 a pop. It's really frustrating, but it's an expense of the contract. As a title company, there's nothing I can do about it. I order them, they give them back, they want their $350, seller's paying for it. Sometimes there will be a transfer fee where the association will charge $100 to transfer it from the seller to the buyer, and they just want an extra $100 is what they're looking for their books. But that's a buyer's expense, line 152. So application or transfer fees are buyer expenses. Estoppel fees are seller. Again, the title company is going to be the ones usually figuring that out and putting it on there, just putting it out there for your knowledge. So now what's near and dear to my heart, title insurance. So again, loophole stuff, at least 15 days if you're getting financing, or 5 days if you're a cash deal. And again, this is negotiable. I often put a 10 in there instead of 15 or 5. But what it is saying is a title insurance commitment will be delivered to the buyer 15 or 5 days before closing. So I teach a seminar. I'm hoping to turn it into a CE seminar. Right now, it's not. I just have to extend it a little bit and get it approved. It's how to read a title commitment. Most realtors I've discovered, maybe they get the title commitment, maybe they don't, but they don't know what it is they're getting. They're just happy to have gotten it. So my job in my next group thing will be to make sure you understand what it is. But the punchline is the buyer needs to get it and needs to review it. Again, that's what I as an attorney would do. Title companies don't review it on behalf of the buyer. The title company sends it to the buyer. Usually the title company is hired by the seller, so they have no reason to point out to the buyer any issues. They pointed it out by delivering it to them, but if the buyer doesn't read it or know how to read it, then that's kind of their problem. So again, I digress into learn how to read a title commitment or give me a call if there's any issues, but at least look at them, but make sure the buyer gets it. Now, again, it is a loophole period. If the buyer has not received it, the buyer has 5 days, and I don't think I have that. It's in paragraph 18A1. But the buyer has 5 days to examine title. So again, when you get a title commitment, there might be something objectionable there, and you only have 5 days to make the objection. So again, it doesn't happen often, and it doesn't get over. I mean, it is what it is. I can't digress into title, but buyers should look at it within 5 days, and if there's an objection, they should make it. Where I'm going is the loophole that I've used to protect a buyer. I had a buyer who needed extra days to close. They wanted to close, but the closing was on a Friday and they couldn't close till Monday for whatever reason. And the seller said, no, Friday you're in default. And it turns out they hadn't delivered the commitment. So I went to the closing. We actually showed up in closing and said, wait a minute, I need to see the commitment before we close. And we weren't ready to close. We didn't have the money. And they handed me the commitment. I'm like, oh, you know what? I need 5 days to review this. And the closing shall be extended up to 5 days to allow the buyer time to review the commitment. So close that loophole. Make sure, I mean, as a seller, close the loophole, make sure the title commitment gets delivered. As a buyer, you may or may not want to close it, but you really do. You want to know what the title is you're getting. But it was a loophole, again, that I like to point out. 5 days to review the title and closing shall be extended to allow that time to review it. So you kind of want to cover that. Now, what else do I have on here? The very important part are A, B, or 1, 2, and 3, lines 168, 72, and 75. The customs of Brevard County would be seller shall designate the closing agent and pay for the title policy. That's why, as a title company, I try to get listing agents to put my name on the listing so that Waterview Title will do it, because it is the seller who picks. Now, to be fair, it's the seller who picks, not the realtor, but in the real world, it's the realtors who pick, not the seller. Again, because the realtors control their clients, which is all real good. So ordinarily in Brevard County, you'd check box 1. However, it is negotiable. This is the custom. It's not a law. This is a contract that can be negotiated. So by way of example, when I buy a property in Brevard County, I check box 2. I say, you know what? I'm going to do the title work. I'm handling it myself because I'd rather do my own title. Thank you. And I'm willing to pay for it because it's my company, so I can afford to do that anyway. So as part of the negotiation, when I buy a property, I put that in there. I have loyal clients who I usually don't advise them to do this. All of us title companies, we're all good. I'm the best, but we're all good. And we all do the same thing. And if we do our job right, each of the various title companies in town are going to do effectively the same thing. So if I'm representing a buyer, I don't want them paying extra to use me. Just pay me my attorney fee and let the title company do it. Now, sometimes I've had clients say, you know what, John, I'd rather you do it. I have a couple of guys who are really loyal to me and they rather pay to have me do the title. They just trust that I'm going to look at everything. And I would anyway. That's what I try to tell them. But you can check any box. Now, if it's in Dade Broward, they have this special provision, which is kind of a hybrid where seller pays for the search and buyer pays for the policy. So you can read that. And then I have on there generally who pays picks. So if I'm the buyer and I'm paying for it, I pick the title company. If I'm the seller and I'm paying for it, I pick the title company. Again, it's a very negotiable thing. So it is what it is, but you should, in filling out this contract, typically check box 1 here in Brevard County. Okay, now, related to the closing cost, a survey, a buyer may, the survey's a buyer's expense. I am a big fan of surveys. I recommend you get a survey. If a seller has a recent survey and they can sign a sworn statement that there have been no changes, as a title company, we can rely upon that. So you don't always have to get a new survey as long as you have a accurate survey that exists and we can have a sworn statement that it's accurate. So there are scenarios with not getting a survey. My recommendation, they cost $300 to $400, again, depending on the size of the property and all, but I recommend it. You're spending $100 or $200, $300 for the property. You might as well see what it is. Survey problems are rare, but when they happen, they can be substantial. A survey is a footprint of the property, the house, the fence, the shed, the easements. And if there are encroachments, the house is over onto the neighbor's lawn or the neighbor's house is onto your lawn, that's a big one. If your pool's extending beyond your property and somebody says you got to remove your pool, that's a big one. These things do happen. Little ones are fences. Nobody cares if you have to move the fence, so you move the fence. But these are minor things are no problem, but when they're major, they can be very major. And the only way you're going to know is with a survey. Yes, ma'am. Well, it varies. 10 years would be what most underwriters would say. I've gone back as far as 20 years when I know the clients and I know the property. So I have some leeway, and other underwriters may have some leeway, but the key is that it be an accurate survey. In other words, it can be, oh, everything's the same except we put a fence, we put up a new fence where the old fence was. I can't trust your fence guy to have done exactly what the last fence guy did. So if you have a new fence, I need a new survey. Oh, everything's the same, but we put, we extended the patio. Well, then it's not the same anymore. So anything that affects the footprint makes it no longer good. If it's truly accurate, there's been no changes. Again, I think the rule of thumb is 10 years. I've gone further if I'm comfortable. And it does have to be certified to the seller. So if the seller, if we're, as a buyer, I'm using the seller's old survey, it can't be a grandfather survey. If the seller used the seller's old survey, we can't continue that daisy chain. I need a sworn statement from the person to whom it's certified. Well, it has to be the current seller. So you can't grandfather, so to speak. Home warranty is a good sales pitch. You check the box if your buyer is buying one, your seller's buying one, or if the realtor's buying one. Some actually they don't have a box for a realtor buying one, do they? But again, that's really a salesman thing. If it's there, fill it in. Special assessments. These are not condo assessments or homeowners association. These are government things. So the example I use, do I have time? Oof. So the example I use for the assessments are street lighting improvement districts. So they've come through your neighborhood and said, we're going to put street lights on your neighborhood and we're going to charge everybody $10,000. It's going to be $1,000 a year for 10 years. It's going to be on your tax bill. You can pay it all up front if you want, but otherwise you pay your tax bill every year for 10 years, $1,000 a year. So if you check box A, due prior to closing, buyer pays after closing, and that is the default. So if you don't check anything, it's box A, then everybody lives happily ever after. Buyer sells, buyer buys it, pays the tax bill every year, it covers the assessment. If you checked box B and that assessment was there, then I, as the title company, discover it, because that's my job, and I see that there's an assessment that's included in the tax bill, but it's a special assessment. And oh, look, we're in year 3, there's 7,000 due. So I do a closing statement, seller is paying $7,000 to, like that line says, pay in full prior to closing. You're going to have a really unhappy seller. So check, be aware, no special assessments. They're very uncommon. It's not a common practice, but the example I gave you is a live example of showing up at a closing with a $7,000 bill and a very unhappy seller, because they just assumed it's part of the tax bill. But if it's a special assessment, it's a special assessment. Now, this doesn't include some other things, but we'll leave it at that for now. Okay, disclosures, nothing to fill in. I'm going to go really fast here. Again, you need to read it. Radon is a silly one. Permits, the important point to know on the permit one is line 210, and line 210 says, the seller does not know of any improvements made to the property which were made without required permits. If they do, you need to inquire from the seller and you need to disclose it if they were. Hey, we put in a back room and we never got it permitted. Well, it could be a problem. Absolutely could be a problem, but you might as well disclose it now, because seller has signed. When the seller signs this contract, even though this is buried on line 209 in the disclosure that nobody reads, they have signed that the seller does not know of any improvements. If after closing, code enforcement comes along and says that back room was not permitted, I'm coming after the seller because the seller didn't tell me about that. And the seller said it. And now if the seller didn't know, again, these are awful lawsuits because it's always a matter of proof and you got to prove that the seller knew. But if you can prove the seller knew, then they have misrepresented fraudulently or otherwise, and they'll be held liable. So again, you got to be honest. We got to deal openly, honestly, fairly with each other. Things that have to be disclosed, even if they're going to hurt the transaction. So that's that one. Mold, the flood. So there is a blank on line 225. I will tell you, my practice is to put the same number of days as the inspection period. So if it's 15, I put a 15. If it's 10, I put a 10. If you leave it blank, it's 20. I've never, ever, ever seen this clause in use. But what it's basically saying is if flood insurance is not available, if you are in a flood zone, but flood insurance is not available, then you can cancel the contract within 20 days after discovering that. But I've not seen it happen. I reread it last night again, and it sounds like, I think there are some areas where you might be below sea level, so maybe you can't get flood insurance, and maybe that's an issue. But again, I've never seen it in play, but it could theoretically be an issue. Energy brochure, okay, again, I don't know, I forgot to ask the other question. How many of you have been practicing for more than 5 years? All right, great. How about more than 10 years? Nice. How about more than 20 years? All right, good for you guys. Okay, so those of you who have been practicing, how many of you give the energy efficiency rating information brochure? Nice, good for you. I have been practicing, well, I've been a realtor for 10 years now, which is amazing to me. But in any event, I don't really give that energy disclosure thing, and that's probably bad, and I probably shouldn't have said that, but so be it. The buyer is acknowledging receipt of it. So you probably should be giving it. I probably should be giving it. The buyer is acknowledged receipt of it, whether I've given it to him or not. So that's one of those kind of funny, weird ones. The lead-based paint one is mandatory. If the house was built prior to 1978, you must give the lead-based paint disclosure. So be aware, it is a separate rider disclosure and it's mandatory. The homeowners association, if you're in an HOA, it's mandatory that you give a disclosure. I hope to have 30 seconds to cover that later, but the HOA is mandatory. Property tax disclosure, it's just a notice to buyers that tax bills sometimes jump up. Seller might have been paying $1,000, but they might have owned it since 1972 with homestead. Now, you might make it your homestead, but you lose their cap and it's going to jump up, and normalize before you start paying. So that's just a little warning. FERPTA, I told you, I'd mentioned before, if you have a foreign investor, which is a non-US citizen, then we may have to withhold up to 15% of the sales price. There are some exclusions to that. But again, if you have a foreign investor, bring it up early. Get it started the day of the contract or when you take the listing. If you have questions, call me, but don't let FERPTA sit because it can delay closings, or it's not so much that it delays closing, it delays funding to the buyer, the seller. The seller is going to have 15% withhold. And if they're not netting 15%, they have to come, sellers can have to come to the table with money to sell the property because of FERPTA. So again, address it early if it's the case. Seller's disclosures, this is critical. Seller knows of no material facts affecting the value of the property which are not readily observable and have not been disclosed to the buyer. Those are significant statements that I said quickly, but no facts materially affecting the value of the property. So if it's not a material issue, you're not required to disclose it, which are not readily observable. The example I always use, if there's a giant hole in this wall right here, you see that hole? You see it? Everybody see it? I don't have to disclose that to you because it's right there. There's a giant hole behind that screen, which let's presume the screen is up against the wall and it's really a picture. People aren't going through the house and removing every picture to check when they do their inspections. So when you move out and you take the picture off the wall and there's a giant hole, that wasn't readily observable. You need to disclose that, and a giant hole in the wall would materially affect the value of the property. So if a seller didn't disclose that, then they're going to have, liability for it. Again, if it's been disclosed, whether by the seller or otherwise, if the buyer knows about it and you can prove they know about it, then the seller's off the hook because it's been disclosed to the buyer, however that's happened. So except for those things, it's as is. And if we get through closing and post-closing and there's a problem, I just got a call yesterday from, I'm not going to take the case because we don't need to, I don't think, unless she gets a letter, but a seller sold 2 years ago and now somebody's trying to do something and FPL is claiming that there's an issue with the box. And, I don't know, I'm not quite sure what the whole story is, whether it was tampered with or whatever. Well, the seller knew nothing about it. And the buyer is now trying to come after the seller for what the cost FPL is claiming is due. It's as is. If the seller knew about it, the seller will be liable. I am believing the client when she said she didn't know anything about it, and therefore she has no liability. You have to find these things out for yourself. If the seller didn't know there was a hole in the wall, I'm not sure how that would be, but if they didn't know, then they don't have to disclose it. They only have to know things known to the seller, not readily observable, and material affecting the value of the property. That is a significant statement. Yes, ma'am. No, okay, great question. Oh, I'm so in trouble. We're not going to finish, or we'll stay late, or both. So seller's disclosure, I don't like that form. And for a while, I'm my own broker. I was my own broker. I jumped over to EXP for a while. I think it's a great company, unrelated to anything. But then I went back to being my own broker again. And the one thing I didn't like about working for somebody else is they insisted on the seller's disclosure, and I don't like that form. So I'm glad as my own broker, I don't have to do it now. But if your broker requires it, you get it. When a buyer calls me and says you have to do it, I say, no, I don't. I don't have to do it. I have to disclose to you what I have to disclose to you. I don't have to use your form. I don't have to use any particular form to do it. It's a great form. It has a ton of information. I'm not wholly opposed to it, but it's very detailed. And if a seller is going to prepare it, they better be accurate. And if they don't know, check don't know. There's a don't know column. Use it. Yeah, use it. By the same token, though, if you do know and you check don't know, you've now lied. So I don't like the form because it's fraught with potential errors that can be held against you. That's why I don't like it. If I don't know something and I say yes because I just like to say yes to everything. So I say yes and I didn't know, I could be held liable for that yes. Or if I say no, and if I say don't know and it was proven that I knew, so accuracy is the key, and it's such a complicated form. It's great, but it's complicated. So you don't have to do it, but you do have to disclose material facts affecting the value of the property, which are not readily observable and not already disclosed to the buyer. So if you disclose it, great. If you don't, and again, your brokers control what you do. I don't control what you do. Legally, I can tell your broker, I'm not giving it to you. And you can tell me I have to have it. I'm like, no, it's your problem, not mine. But if your brokers want it, again, sometimes I'll be cooperative and help, but that's the rule on that one. Okay, we have one more paragraph. We have 8 minutes. Oof. Property maintenance. So these are as is contracts, except the seller, it's as is as of the date of the contract, as of the effective date, right? So if the lawn is well kept and the pool is blue and everything's wonderful, then at closing, the lawn has to be well kept and the pool has to be blue and everything's wonderful. If you're in one of these short sales or distressed property situations and the lawn is not well kept and the pool is green when you sign the contract, then we don't have to clean up the pool. We have to maintain it in the same condition as when you sign the contract. So if that means taking care of the property, which it usually does, then you got to take care of it. You can't let it go overgrown. Beyond that, that's the as-is maintenance requirement. This is the as-is contract. Buyer shall have blank 15 days of left blank to have in any inspections they want during the inspection period. So 15 days is a reasonable number. In today's world, sometimes sellers want you to go to 7 or 5 or 10. Again, don't do anything you're not going to be able to accomplish. Don't set yourself up for failure, or set yourself up to have to cancel a contract that you don't want to cancel. But if you need to rush it, if you got to get an inspector out there, get them out there. Don't dawdle either. So 15 is reasonable. I often pop a 10 or a 7 in there, depending on whose side I'm on and the facts. But the punchline is, if buyer determines, and buyer's sole discretion, there's that language again. And this stupid example I use is, I walk up to the property and stub my toe and decide, ooh, this property's got bad mojo, I ain't buying it. I can cancel for any reason at all. I sneezed and I don't want to buy the house. I don't need an excuse for 15 days. We'll use the default, 15 days. Come day 16, I'm done. The roof could be caving in. If I didn't cancel on day 15, that's my problem. So you got 15 days to deal with it. And then on day 16, it's done. So if you want to cancel, here's the crazy part. Buyer has 2 choices and the seller has, none sort of. So the buyer's 2 choices are keep the contract and take it as is, or cancel the contract. That's it, contractually. Accept it as is, cancel. Now, what happens is we do the inspection, we realize it needs a couple $1,000s worth of repairs. So we go to the seller and say, look, it needs a couple $1,000 repairs. Let's do an addendum for a couple $1,000. The seller can say no. Buyer's choices, accept it as is or cancel. They can't say you have to. No, they don't have to. They're allowed to say no. You have your choice. Take it as is or cancel. So it becomes a leverage who's going to blink first. And that's what it is. Typically, if they're the type of repairs that every buyer is going to bring up over and over again, the seller's got a bird in the hand. He's going to have to fix the Federal Pacific electrical panel at some point. He might as well suck it up and do it now and pay the $2,000. And otherwise, he's going to just keep losing contracts because of it, right? So you negotiate it and you get it done, and that's perfectly fine. You do an addendum. Be wary. Again, I don't mean me, but if we're negotiating on day 15 and I don't get back to you till this day 16 and you haven't terminated and we haven't signed an extension, and day 16 rolls around, I say, you know what, we're not going to do anything. And you're like, well, then we're canceling the contract. No, sorry, it's day 16. You don't have the choice. So you have to either get an extension, which is the most logical thing to do, convince the parties, let's give us 5 more days to negotiate or whatever, or get estimates or whatever we need to do. But if the seller is playing a game, your only legal option is to cancel or accept it as is. You don't get to force them. And if you don't cancel, they get to force you. So you've accepted it as if you don't cancel. So just a little warnings there. Now I really got to move because 6 minutes is not happening. So walkthrough inspection is only to determine that it's as is maintenance. If there are permits and things, seller will cooperate. They do not have to expend any money to fix anything. It's an as-is contract, but they do have to cooperate with you to fix things, and they assign contracts. That's easy. Okay, I'm going to skip some of this. Escrow agent, you can read it. Professional liability. The good news there is buyer, it's in nice big bold 318, buyer agrees to rely solely on seller, professional inspectors, and agencies for verification. Now I put the realtor hat on, we are salesmen, right? Our goal is to sell the property. Anything we say is salesmanship. So you are not, the seller, buyer is not allowed to rely on anything I say. The contract is what controls, or inspections or appraisals, not John Lack. I'm going to sell you. I'm going to tell you this is a great price. This is the best house on the block. It's wonderful. And you can't hold me liable. This wasn't the best house. It was the second best house, John. Well, all right, too bad. So I'm not liable for anything I say other than misrepresentation. Of course, we lie. That's not salesmanship. That's fraud. So you can't lie, but I can sell and give opinion that's not legally binding. Default, if buyer doesn't do what they're supposed to, seller keeps the deposit. That's the primary thing. A seller could seek specific performance, but it's a very hard road. And just assume, again, I won't say it couldn't happen, but just assume that the seller is going to keep the money if the buyer defaults, and make sure the deposit is enough to compensate them for doing so. If the seller defaults, the buyer can either get their deposit back and sue them for damages. Damages is costs. It's not lost profit. It's not expectation. It's not time. Unless you're an attorney billing your time, a buyer doesn't get to say, I spent all this time and you didn't sell it, you owe me money. You can only bill for inspections, appraisals, loan applications. So it's costs, plus you get the deposit back. Or you can sue the seller for a specific performance. Again, very uncommon, but it does happen. The reason it's uncommon is it can take 6 months to a year, and most buyers don't want to wait 6 months to a year to buy a place, so they might be mad, but in the end, they'll go away. So there's a lot more I could unwind there, but no time. Dispute resolution is by, if there's conflicting demands on deposit, you go to mediation, then arbitration. If there's a lawsuit, then it goes to court. Mediation and arbitration are split attorney's fees. Court is prevailing party attorney's fees. Again, it's relevant, but we don't have too much time to discuss that now. Okay, standards. I'm really cheating here, but there's all the standards. You need to read them. I am going to point out a couple. So I don't have time for the title one, but I already mentioned it as far as the one I do want to point out. So jump to page 7, paragraph line 382. This is a residential contract. It's not going to be on your screen, so you're going to need to look in your manual there. So it's standard 18A, but it's the contract on line 382 says that this contract is for residential purposes. If you were doing something specific, like you wanted a duplex or you wanted it for an Airbnb or something like that, put in the special clauses that you have this special use, because it may be able to be a single family home, but you might not be able to use it for your intended use. And if you want to be able to get out of the deal during your inspection period, so to speak, you need to make it clear that it's subject to that. So again, you can read that paragraph 18, and then we already went over the title examination, discussed survey. You do need to confirm there's ingress and egress. Leases, we already talked about estoppel letters. If there is a lease, you need to get an assignment of lease. Again, really more of an attorney function, though realtors might be able to do that, I'm not sure, and or title companies, but if there is a lease, it should be assigned at closing. Time, we already discussed. conveyance is marketable title. Location of closing will be at the title agent in the county where the property is located or by mail, et cetera. Seller will provide documents, we're good, procedure, blah, blah, blah. Prorations are as of the day of closing. The buyer owns the day of closing. So taxes and stuff are prorated the day before for seller, from the day of closing forward is the buyer. And reprorations, there is a clause in here that says it's built in. You're going to sign it at closing as well, but there's a reproration provision, meaning if the tax bill went up, the seller owes the buyer money. It's built into the contract that it survives the closing. So they've agreed to make good if the tax bill were to change during their time of ownership. Risk of lie, I just don't have time for that. So the one that I have to discuss, paragraph O, big stars on lines 530 through 533, critically important. Notice given to a broker or their agent. So notice given to you guys is, and or to me as an attorney, is deemed a notice given to our client, the seller or the buyer. So if I send you the title commitment and you don't send it to the buyer, and there was a major title objection, the buyer's got 5 days from when I send it to you, not from when you send it to the buyer, because the delivery to you constitutes delivery to the buyer. So if I send you a notice, make sure you get it to your client, because they're deemed to have received it, whether they got it or not. You're their agent and you have received it on their behalf. So please, 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 for your own sake, make sure you forward notices that are forward commitments, forward anything that's time sensitive, because the buyer has a certain number of days to respond. And if they don't, and you're the buyer's agent and you didn't tell them about it, they've waived a right. And again, that can come back to haunt you. So be aware of that. The contract is the final terms here. That's what integration modification means. It has to be collected fund, blah, blah, blah. FERPTA we talked about. All right, so we raced through those, but I'm already late now. I'm so sorry. So the addenda, the mandate, okay, so if checked, you need to attach. The fact that the addenda, you check the box for condo rider, that's great. That tells me that there is a condo rider. Checking the box is not attaching the condo rider. You need to check the box and attach the condo rider. I get a lot of contracts with boxes checked and no riders. Where's the rider? Well, we checked the box. That's not the rider. That's just telling me that there is a rider. So please check it and attach the rider. The mandatory ones, if it's a condominium, you got to have it. If it's an HOA, you got to have it. If it's FHA, you got to have it. Short sales isn't mandatory, but I highly recommend it. Lead-based paint, if it's pre-1978, you got to have it. And this is the one that many of you don't even know about. If you're involved in the transaction, by which I mean it's you, your husband, your children, your parents, if you are related to the buyer or seller, you need to check the licensee property interest one, which is AA, and attach it. It's no big deal. It just says, I, John Lack, am the seller. And, you know, it says, I am a realtor and I am the seller. It's crazy. I don't have to disclose that I'm an attorney, but I do have to disclose that I'm a realtor. You guys have to disclose that you're realtors and are interested. The idea is that you have knowledge above and beyond your layperson borrower or seller or buyer. And so they should be aware that you have a personal involvement and therefore have a personal interest with your extended knowledge. So those are the ones you have to add. Almost done, almost done. If you got to leave, I understand and I apologize. Additional term, no, it's my fault. So sorry about that. This is a legally binding contract. Beware of legalese, be precise, avoid ambiguity and vagueness. If you're adding any additional terms, call, unless it's incredibly obvious, call me. Things that seem obvious are not always obvious. Buyer shall give seller a $3,000 credit at closing. That's easy. Buyer shall credit, or seller shall credit buyer $3,000 in closing costs. Define closing costs. Does closing costs include prorations? Does it include seller's closing costs? What does it include? You know, is it escrow deposits, things like that? So be wary, make sure, have a friend read it. Is this precise, ambiguous? Can somebody interpret this somehow different than I was thinking of it? You know, just be very careful and avoid any kind of legalese. If you find yourself trying to draft something, call me, don't do it yourself. Counter offer, they eliminated the rejection option. So, but they still left the seller counter offers. I've never seen these lines checked, but there they are. Signatures, authorized signatures for the party. Again, if it's an LLC, it has to be an authorized member or manager. If it's a corporation, it should be the president. If it's an estate, it should be the personal representative. Trust, it should be a trustee. Obviously, buyers, sellers, you know, husbands, wives, etc. Whoever's supposed to be signing. You need to date it. Again, we're using DocuSign, it automatically dates it, that's great. But you need a date because the effective date runs from the date the last thing is signed, so we need to be able to identify that. I am a fan of putting the addresses for notice. A lot of realtors don't put their client's address, and then I need to call you to reach them. Fine, if that's what you want, it's okay with me, but appropriate preparation of contract would be to include the address. Phone numbers and emails. When I prepare the contract, I put address, telephone, and email. I put all three, I make it fit on those 3 lines because I want my people to have easy access to all the information. Again, it's just information. There's no reason not to put it out there because it makes it easier, but that's me. So in this part, again, CFPB requires, the closing disclosure requires that we have your license numbers and your broker's license number. And so if you have it, again, I know how to look, and I'm a realtor, so I know to go to DPPR, and I'm sure a lot of the title companies know to do it, but it's a pain in my butt to have to log into DPPR. I have to look up yours, and I have to look up your brokers, and I enter the information. If you can just write down your license numbers when you're preparing the contract, sure makes it easier on the people down the road. And as far as the commission, it is okay. This is one of those ongoing conflicts. It's okay to write the commission as 3% or 2.5% or 2%. You're not allowed to negotiate it. So the commission is what it is. If you write it down here to disclose it so that Linda doesn't have to call you because it's right on the contract and she knows what the commission is, cool. We have the commission on the contract, we go ahead and do it. But if the listing agreement said 2% and you write 3%, that's not, you don't get to modify it. This is not, hey, I'm making an offer, but only if you pay me more. Or really the reverse is true. The seller says, I'll accept your offer, but only if your realtor accepts 1% instead of 2%. That's not negotiable. And thankfully, as realtors, the offering commission is the offering commission, and we're not required to take less. And it can't be modified by the parties, by the buyer and seller. They can't change what the seller has already agreed to. Of course, we can change our mind, but they can't. But disclosing it is perfectly okay. So they did remove the initials on page 12, which is interesting, but there's initials on every other page. So make sure when you're signing it, you're also initialing the contract. And then don't give legal advice. This is a legally binding contract. Once it gets signed, I always beg clients, if you want me to represent you, please send me the contract before you sign it. If you send it to me after, I'll still represent you. I do a lot. I earn my fee even after you've signed the contract. I'll review everything. The things we talked about, I'm very diligent in my job, but I can't change it once you've signed it. So if you signed it, all I can do is say, all right, this is what you're bound to. If you get it to me beforehand, I might be able to negotiate something. And again, maybe, maybe not. Most things are pretty routine, but I'd always rather see it before it's signed. But that said, I think that's the end of, disclaimer, there's an approved form, but the details should be negotiated between the parties. That's again, the Florida Bar disclaimer. And I think that's me. Now I was supposed to, so anybody who has to leave can leave. I will stay and answer questions, but I'm going to do my 8 minutes late. I am so sorry. I thought I was doing better too. So condo rider, HOA rider, condo rider. If it's a condo, you got the condominium rider requires disclosures. A buyer has 3 days from receipt of, and I don't know if you guys have this in front of you, but it's paragraph 5 on the condo rider. They have to receive current copy of the Declaration of Condominium, Articles of Incorporation, bylaws and rules of association, a copy of the most recent year-end financial information and frequently asked questions and answers document. You have to get all of that. The buyer has 3 days from receipt of that laundry list of stuff to cancel the contract, 3 days from when they receive it. So again, closing is in 3 days. They haven't received it yet. They need an extension. I call up or they want to cancel. I call up and say, hey, by the way, my client, can you send me over the condo docs? Oh, wow, we don't want to buy this. This is ridiculous. I have 3 days to cancel the contract at any time in that 3-day period from receipt of the documents to 3 days from receipt of the documents. So close that loophole. Make sure they get the condo documents. There's a place on here for them to request them, and there's a place on there to acknowledge receipt. If they've already gotten them, fill in the acknowledge receipt spot. But otherwise, again, an email, any proof that you send it to them is good enough. I'm not worried about what you have to say to a judge as long as you can show that you sent them. But They own, and again, this is where you as realtors, if you're a buyer's agent and I send it to you, the 3 days goes by, boom, it's over. So I've been in that scenario where I've been a buyer and I've tried to cancel a contract on behalf of the buyer. And it turns out the buyer's agent had gotten the documents. So that loophole had gotten closed. So again, be very wary as agents that you pass on information, because 3 days is 3 days, and be very careful to, when you're on the seller side, close all the loopholes. Give the leases so that the 5 days runs, give the condo docs so that the 3 days runs, so that you don't have these loopholes for somebody like me to try to save a buyer's deposit. I'm going to look for anything I can to get my client out. And if you missed a deadline, I'm going to use it. So be aware of that. HOA rider, same thing, 3 days. However, interestingly, 3 days from receipt of the document, this document, not a whole laundry list of stuff, just this. So as long as you attach the rider to the contract, you check the box, you attach the rider, they initial it here, 3 days starts. So they got 3 days. So there is like a 3-day cancellation period, but it's typically 3 days from the signing of the contract, because they've typically signed it and gotten this. This is just telling them you are part of an HOA. There are monthly or quarterly or whatever assessments, and there are documents that you can look up yourself. We don't have to provide you the documents. Condo, you have to provide the documents. HOA, we just have to tell you they exist and you can look them up yourself online. So it's a little bit different, but 3 days from the receipt of the paper, 3 days from all of the documents, very, very important things. Thank you for attending and have a great day. I will stay and answer any questions. 11 minutes late.